And Lordship. Lordship, I would like to mention item number 3, Lordship.
Item number
3, Lordship.
3.
Yes, Lordship.
Yes.
Lordship, may allow to withdraw this matter, Lordship. This matter is in process, Lordship.
Yes, State Council.
Yes, it was transferred question maker.
So Learned Counsel for the appellant submits that he has instructions not to file this writ petition. Where? 3 G Tarak, Learned Standing Counsel RW. And your
Private respondent.
name? And Sri so Learned Counsel for the private respondent do not have any objection. Where? In view of the above, the writ appeal stands dismissed. Have not pressed.
Much obliged.
None to the order. Item 1. Yes, who's there? Anybody online?
Yes, Lordship. May it pleases your Lordship? Yes, my Lord, I am here
Yes.
online, Lordship. Sorry for the inconvenience, Lordship.
Okay, but you are not visible.
Yes. Am I audible, Lordship?
Yeah, we can hear you. What is this?
Yeah, this is a PIL, Lordship, item 1. This is a PIL with regard wherein the petitioner had surveyed in 6 villages and under in the district of Changlang, Lordship, in Miao, Bordumsa and Changlang subdivisions, Lordship. 6 villages.
When
he
did
had
you
surveyed.
make when did you make the survey?
Survey in the month of November, Lordship. Thereafter,
Okay.
petitioner, along with other fellow villagers, they have made with 2 practicing lawyers, they have surveyed and they had made a the petitioner himself had filed a representation, Lordship, dated 15 to 2025 before the authority, Lordship, wherein he had stated his grievance that there are no Anganwadi centers and wherein there are Anganwadi centers are there in villages, but it's in a very dilapidated conditions, Lordship. Broken walls, broken roof. And in the report, Lordship, which is annexed, the photographs also are annexed along with the report where he made that survey, Lordship. And which is under the Integrated Child Development ICDS scheme, Lordship, wherein the guidelines and the framework is being given, how to implement and also as per the requirement of the National Food Security Act, Lordship, Section 4, then Section 5, Lordship, Section 4 of the National Food Security Act, which says that subject to such schemes as may be framed by the central government, every pregnant woman and lactating mother shall be entitled to meal free of charge during pregnancy and 6 months after childbirth through the local Anganwadis so as to meet the nutritional standard specified in Schedule 2 to the Act, Lordship. And as per Section 5 of the National Food Security Act, the implementation of it is done through the Anganwadi centers, and wherein the Anganwadi centers are not available in this, particularly this 6 districts, 6 villages, Lordship. Lordship, I humbly pray at this stage, if notice is issued, Lordship, oh, okay.
And that too in a bench of Arunachal where hardly we have 1,500 cases.
Yes, madam. In fact, even the writ petition, which is stated to be pending before the principal state, that also is,
Sri Disoki, learned counsel for the petitioner who submits that he has entered appearance recently.
Today, madam,
Uh,
or
today,
instructions,
yes.
madam.
Recently, full stop. Recently, as the earlier set of councils have withdrawn. Para. Also heard Sri N. Ratan, learned AAG, Arunachal Pradesh, full stop. Para. The instant writ petition was filed with the following prayer, with the prayer. Full stop. Sri Ratan, the learned, I don't say prayer, instant writ petition was filed challenging the vires of the Arunachal Pradesh Entry Tax Act 2010. The certain provisions, entire act has been
Enter,
changed.
enter.
Act has been-
Para. Sri Ratan, the learned AAG, has however submitted that by influx of time, nothing survives in this petition.
In fact, it has been repealed.
Repealed.
No.
Entry tax act has been repealed.
Oh, Sri Ratan, the learned AAG has submitted that the impugned statute, not impugned, the act in, sorry. The old files. 15 years.
My lord.
You see the effect.
Yes.
Once you open it, you'll start sneezing. Physical effect.
Yes, physical.
Has submitted that the act in question has been repealed, and therefore there is nothing And therefore nothing remains to be adjudicated. Full stop. Sri D. Soki, Learned Counsel, do endorses the aforesaid principle, has further submitted that he has no specific instructions to withdraw the writ petition. Not to say withdraw, not to press this writ petition.
My lord, please, my lord, just record that I had sought for some 1 week's
And-
time to
And
instruct the
he
petitioner.
has also prayed for further time to seek instructions. Para? After considering now we have considered the rival submissions. Para? Do time has been sought for on behalf of the petitioner. Considering that this writ petition is pending since the year 2010 and on innumerous occasions, time was granted to the granted on prayers made by the petitioner. This court is not inclined to grant any further time. Full stop. In fact, when this matter what was taken up yesterday, the following order was passed, 14-5 order. Para, considering that the act in question has been repealed and by considerable elapse of time, in the meantime, we are of the opinion that nothing remains to be adjudicated in this writ petition, and accordingly, the same is dismissed. The interim order passed on 6/12/2010 stands vacated.
Item number 4 to 6.
Yes.
Yes, 4 to 6.
For item number 5 on behalf of Mr. Lee Mazumdar, he is appearing online.
Okay. Yes, Mr.
I'm-
Mazumdar.
I'm sorry, I couldn't go there. Lordships will excuse me, I'm appearing online.
You're not excused. You may be imposed cost also for not appearing in person.
Judges are understood to be very liberal, they have got a
Liberal in
long.
imposing costs. Yes, we'll be very liberal in imposing costs. Personally, upon the senior council. Yes.
I'll be obliged, man.
Yes, yes.
I'm in item number 5. My lord, this is an issue relating to the my lord, retrospectivity of their promotion. They are presently serving as assistant engineer, and they were promoted in 2000.
4, 5, 6 are connected.
Connected, my lord.
Again, the
Connected.
same judgment.
Yes,
judgment.
my lord. Yes.
Judgment.
4 and 5 same judge.
I will take together.
4 and 5 same
And
judge.
6,
6 is my lord, judgment is
Different judge.
different judgment,
but
Same
same
is-
principle.
it's same.
Same issue.
Okay. Now, if the councils are in consonance and having a consensus, then we can admit this and have this for hearing.
That can be only one, madam. Yes, madam, that can be done. Madam, Lordship will kindly have a look at the last order passed on 6/5/2025. In fact, on 30th of April 2025, the learned Standing Council for the Power Department was directed to produce certain records.
You've got the records.
Yes,
Mr. Verma? Got the record that he has got the records.
He has got the records. Now, I'll leave it to your lordship, but otherwise, my lord, the issue is, my lord, presently they
No,
are
we can
working
have
as
this
assistant
for,
engineer.
we can pass an order, we can come to an understanding that it will be listed for admission, but admission hearing for disposal of the matters.
Yes, my
But
lord,
there
yes.
is no requirement of further exchange of pleading.
No,
It's a
my
writ
lord,
appeal.
no. No, my
So
lord,
we-
yes.
Okay. Yes,
Lordship can pass it on.
tell us the date of your consensus, because matters appears to might need some time.
Yes, sir.
It will take some time. Madam. No, I'm
Take care
subject to
for-
my subject
care
to the
for-
my lord, subject to the convenience of my learned friends on this honorable court. My 27 would be
27th
my lord.
of
May this month.
27th of
27.
February.
It's a Tuesday, my lord.
27th. Okay. But one part you have not addressed,
My
the
lord.
first part, cost part.
And I'll leave it to you. I know, my lord, the judges are very, very, my lord, kind and liberal, my lord. So I'm relying on that, my lord.
Okay, heard, so, accept the kiri, online. Who's assisting you, Mr.
Bibor, I'm
Pankaj Bora, madam.
Bora.
Pankaj Bora.
P. Bora, huh? Baki ka also heard Parme, Power Department, then Vaira, the State Council, and Mr. Panging for
My lord, in 4 and 5, 5 to 24. Both.
private respondents,
Private.
4 and 5,
Yes, 4 and 5.
5 to 24. Huh? The Planet Council for the parties are that these appeals can be taken up for final disposal at the admission stage itself and has agreed upon and has suggested that a date be fixed. As agreed upon, list these appeals for admission hearing on 27
Ma'am,
5.
ma'am,
Okay.
deeply obliged.
Number 7.
If I may, my lord. My lord, the service in respect of respondent number 2 is awaited.
You are appearing for respondent number 2?
Yes, yes.
Okay.
I filed my Bakalatnama this morning only.
Records have come, madam.
Not yet, Lordship.
Appeal has been admitted, I believe.
It has been admitted, my lord.
No, trial court records have
Oh,
been.
sorry, Lordship. Yeah, we have paper book also, Lordship.
Oh.
I'm sorry. Yes, Lordship.
You have not gone through the file.
No, Lordship, because this is Lordship earlier.
No time,
Yet,
no time, over.
Lordship, actually, this matter is handling by other additional PP, Lordship. That's right.
How many witnesses?
Pardon, my lord.
How many witnesses?
Witness.
How many PWs?
Going to see.
PW, Lordship, 14 PWs, Lordship.
14.
Yes, Lordship.
Yes, we can have this for hearing. Matter is of which year? 2020 will come in its turn.
May I
Yes.
please, Lordship?
Okay,
May I please?
yes.
My lord, I have not received the copy of petition.
Now we will direct the registry to give you a copy. Heard. You are Talo,
Gitalo, my lord.
heard Sri G. Talo, learned counsel for the appellant, also heard Miss L. Hagi, learned APP, Arunachal Pradesh, full stop. 3.
L. Teni. L. Teni.
Learned counsel has entered appearance for the respondent number 2, full stop. We have seen that the paper book in this appeal has been prepared and accordingly, the same can be taken up for hearing. List for hearing in its turn. Registry is directed to furnish a copy of the paper book to Sri so-and-so learned counsel for the respondent number 2. Yes.
Right, Lordship.
in analogous matter, already delay have been condemned day before yesterday.
First time it has come.
No. Here
Notice was issued.
already issued. Okay.
Who's appearing?
Mr. Pangin was order.
Panging was there. Where is Mr. Panging? Deep Panging. Mr. Panging, same order will pass.
I'm sorry, my lord,
IA for delay condemnation. Yesterday, we
Yes,
had-
yes, ma'am.
how many days delay?
346. 346.
I'm sorry, but I missed it.
Doesn't matter. 346, Kali order to assign into model. Not too much. Same order will pass. We have condoned the delay. I has been allowed. The writ appeal will come up for admission after a week.
No, all right.
Writ appeal to be registered না করে এটা already registered করে দিই করে দেয়া করতে পারি
Your lordships, I'm sorry, man, we forgot to mention item number 6. For the learned single bench, the judgment was passed by Honorable Justice UK Nair. So 27 Justice Nair is sitting. It may not be possible to be listed.
So,
yes Mr.
yes,
Bora.
Mr.
You
Mut-
tell us a date, we don't have an issue.
yes, it's 12th of June, my lord,
12 June.
12th of June.
12 June.
Hmm.
Right. I'll go to 12 June for you. Or it is registered to না লাগে huh? To appeal to be listed for admission of the rule.
My lord, this matter is for hearing or for hearing, your lordship. This matter may be taken up on some other day, my lord. Say 302 matter, my lord.
How many, okay, we'll have some other day.
Lordship, total, my lord, 9, including DW 1 and 2.
Including.
Yes. Otherwise, prosecution.
7 plus 2.
Yes, your lordship. 7 plus 2. He said, the husband has been convicted for Ellie's murder of the wife.
No, we can complete yesterday.
Yes, your lordship.
Yesterday we are in the
Yes, part
midway
of-
of hearing.
yes, yes.
On a request made by Sri Swensa Learned APP. Where is your colleague? Jeannie, legal aid counsel?
My lord, actually, I have informed him.
Okay, okay. The matter is adjourned to be listed after 2 weeks.
Yes, your lordship. Deeply obliged, deeply obliged.
Plate, Your Lordship. I will just highlight some provisions and some cases. So JJ Act and then POCSO Act.
I don't need this file. I'll just make this back. What is this? No, this is something else. No. This is the question. Yeah. This is not the question. This is something else. This is a different one.
Victim determination. Victim determination.
I'll just take to
Just a minute, please. Yes, please continue.
yes, may I, Lord, just take to the criminal revision petition, Your Lordship. In criminal, in the criminal appeal, I will just take to the relevant pages, which is a part of the record. 174.
174, we need
Yes,
the
Your
record.
Lordship. May I read 174? What happened, Your Lordship? The birth certificate which they have relied upon, it was not part of the investigation. In fact, it was placed before the special court after the 1 year, after a charge sheet, after 1 year of the charge sheet. So the application, Your Lordship may see in page 174. It is application was filed under section 231 CRPC for adducing additional document in favor of the victim. In favor of the victim, in that application, they have enclosed the matriculation certificate and then birth certificate, which is in page 178, which we have disputed.
You want to contend that the date of birth certificate, which has been relied upon by the trial court, was never a part of the investigation.
Investigation.
And what was part of the investigation was not exhibited.
Yes, only the matriculation. Even matriculation, Your Lordship, even matriculation also they have enclosed, Your Lordship, 177. Matriculation and 178 is the birth certificate. Huh?
But they were.
Okay. In fact, I will
The
just.
seizure of the birth certificate, that will just come in the witness.
But yeah, sorry to give the wrong information. As per birth certificate was there, but then that matriculation certificate was placed.
But we need only one certificate.
Yes,
Under 94 of the JJ Act,
yes,
there are 3 modes:
3 modes.
birth certificate, school certificate, or ossification.
School living certificate also
School,
important.
any one of the.
Yes.
You have the birth certificate.
But in their case, what I want to submit is that the application which they have filed, that was allowed, but then our application which we filed was rejected. Which we have filed application under section 91 read with 311 CRPC to adduce the first birth certificate which was not part of the report. But then that same was rejected.
But their proceedings had come to the higher court, to this court,
Yes.
and that is the finality of the proceedings. So how do you reopen in an appeal which is not a part of that? It's a different appeal.
But then, my lord, the way the document which we wanted to place, but that was not because
Is a collateral challenge permissible? No, not permissible.
my lord, what I want to submit is that as a special court, when he is determining the age under section 34 subclause 1 of POCSO, read with section 94 subclause 1 of the JG Act, he cannot the burden of is upon the prosecution. He has to prove that the date of birth is correct, not on the accused. But in the case of the offense, yes, burden is proved on the accused. But then in case of the age determination, burden is on them. So in our case, the Evidence Act 35, it says that when another Evidence Act, if the record is placed before the special judge for age determination, then if there is the discrepancies, he came to know, then under section 311 CRPC, the evidence call the major witnesses, especially the first school attendant, which we have placed, and the date of birth, first date of birth, which was issued by the authority, they should have.
No, Mr. Mao,
Yes.
to impeach the prosecution case so far as laying of foundational facts is concerned, you had adduced two evidence through 2 numbers of witnesses.
Yes.
And both the witnesses were adduced in connection with nothing but the age of the child
yes.
involved.
Yes,
And you had tried to discharge your burden by saying that she will not come in a definition of 2D
yes,
of the POXO Act, and therefore not a child, and therefore a offense under the state act may not be made out. But to prove that, see, this age determination by adducing evidence through somebody third party is proof on the basis of documents.
yes,
Records, it cannot be a personal knowledge. He's the headmaster, he has seen some documents. The documents which he had placed before the court, we have also checked. The court has come to a finding that the originals were not even produced.
but we have filed application, Your Worship. We have
For-
filed, we have filed the application for adducing the
No, that was allowed.
original documents.
No, what was the evidence then? By CW1 and DW1 and DW2. CW1
No,
and CW2.
my lord, that was the court, the CW1 was a court witness,
Yes,
another was a different witness.
yes.
But whereas we have filed application saying that the originals first the date of birth of which was issued which date is 2002, it should have been adduced.
No, Mr. Mount, we have noticed, in this case, there were two defense witnesses. Apart from that, there were two court witnesses also.
Yes.
Court witnesses, why were they called for? Only to dispel any doubts on the issue of the age. This CW1 and CW2 are neither witnesses produced by the prosecution nor by the defense. These are court witnesses. Who are these court witnesses? The principal of that particular school. He has produced that class 10 certificate where date of birth is 2002, which may come in your favor.
Yes.
But this certificate is not original, number one. CW2 similarly is the additional register of birth, date and birth. In the cross-examination, he said that this normally birth certificate has to be applied within a month, and if not, then affidavit is required. So how will it help you? We'll
In fact,
we'll get
I have
the
some
clarification
judgment.
from the learned.
I have
people.
some judgments which I want to place. Yuva Prakash is 2000. It says that the burden is on the, especially on the prosecution to prove. When we say that there is a discrepancy in the age, because not only on the record, we also place the application that there is another first birth certificate is there, first attendance school register is there. We have placed filing RTI, we placed before the special judge. Now, if the special judge prima facie come to know that there is a discrepancy, there is a dispute, then it should have been the view of the special judge to summon the person who is the authority of the records under section 35. Sections.
What about this CW1 and CW2?
But then important is under section 94 sub clause 2. Important is the first attended school. So first attended school should have been the record should have been called, especially the register. The record of register should have been called. That is one. And second is that the first date of birth, which was issued, that is issued by the Balukpum birth and deaths register. So this is a two important document. If this the document record holder, so the authority or that record should have been called from this two authority. One was because for the JJ Act 2094 sub clause 2 says that first is the school attended, second is the matriculation, third is if not both certificate are not, then corporation certificate issued by corporation, or last is the authentication test. But in our case, first attended school, it was not a part of the investigation, and then first birth certificate was also not part of the investigation. But then we have
birth certificate was there, matriculation.
but that was the second birth certificate, which is contradictory to the first birth certificate, which is we have obtained through RTI. So that also we placed before the special judge. Now there is a dispute in the birth certificate, and age determination can be done any stage of the trial. In our case was that I'll just place I think important how even if matriculation certificate is available, it should be credible. I will just place and that is one. Another is that as per the JJ Act, section 54, 18 sub clause 2, it talks about the determination of age. That is,
Please bring the yes. Wait.
54 sub, 54, 18. Sub clause 4, which talks about for the age determination of victim in relation to offense against children under the act, and the same procedure mandated for the board and the committee under
You are reading what section
section 54
of?
JJ Act. This is section 54.
54.
Section 64, clause 18, suppose.
It is Juvenile Justice Care and Protection of Children Model Rule 2006.
Rule, not act.
Yes, Act, sorry.
You're saying act,
Rule
confusing. Rule 54.
54, 18. Sub clause 4. Earlier act, there was no provision for the determination of prosecutors, especially a victim. But in as per the new rules, it has
Also heard. Here, APP. Arunachal Pradesh and Tungan. Wicket, what?
RL.
Anand Tungan, learned counsel for respondent to. Hearing is concluded, judgment is reserved. Okay, we sit in 5 minutes.
Okay, by way for listing of an unlisted matter today with section 11 application. if possible.
Section 11.
Yes.
What is the urgency in section 11?
We will file it.
Hmm?
We will file it today.
What is the urgency in section 11? We may not have time. We don't mind taking up your matter. But there are so many matters. Try, since you have come from Guwahati, some privilege you are getting.
May I please, my lord? Well, I'd like to mention item number 44.
Yes.
We are supposed to file our objection today, but we are not ready with that affidavit of objection. 44.
Are you for stay vacating?
No, my lord, we are objecting for condonation of delay, my lord. They filed for condonation of delay.
Okay. Yes, have you informed the other side?
Mr. Kato, yes, I've informed.
Okay.
But the matter is anyway, actually, 44. The matter will be anyway fixed for 20th of this month. That is Tuesday, coming Tuesday.
Okay,
We are supposed to file on or before 20th. So by 16th.
okay. When will you file?
My lord, maybe by Monday, my lord, because this council is from Guwahati. So,
We grant you a week's time?
but this is met by the last. This is fixed on 20th. 20. Yes,
Today is what?
16th.
We'll have it on 28th?
Yes, my lord.
Okay, by the time you file it.
My lord.
Shri H.K. Jamu, learned counsel for the respondents,
Yes, my lord.
both the respondents.
Yes, my lord.
Has submitted that the principal matter is fixed on 28th.
Yes, my lord.
And so far as the present I for condonation of delay is concerned, he prays for some more time to file the objection.
My lord.
Para, in view of the above, list on 28th, 20, by which time the objection may be filed.
Oblige, my lord. May I please, your lordship?
Be sponsored.
May I please, your lordship?
Yes,
Lordship, with the consent of the parties, I pick to mention item number 17 and 18, lordship.
17 and 18.
Yes, lordship.
Yes.
I'm praying for an adjournment for today, lordship. May I pray for fixing the matter on 16th June, lordship.
You're for whom?
I'm for the petitioner, lordship.
inform the other side.
Yes, I will follow.
Yes, Mr. Tarak. On a prayer made on behalf of the petitioner, matter is adjourned to be listed on
16/6.
16/6. Separate orders, huh? Matter is bola, na? Separate orders.
Deeply blessed.
Same order but separate. Okay.
My lord, I want to mention unlisted matter. Unlisted matter, the
Unlisted what? What
civil revision petition.
What is the urgency?
Urgency is that Lord, tomorrow this deputy commissioner, someone issue me, so I should appear with him an execution petition. While this order issued by the circle officer, Pijarang Circle, Pakikesang district. So DC had summoned me to appear tomorrow. Without any reason, I'm being pleaded in case. So I'm challenging against
You
the,
don't want to appear before the DC.
and I'm challenging against
Go
the,
there. What is the problem?
Lordship, I'm challenging against the execution order passed by the circle officer. So DC has issued me summon. So I'm challenging the execution order. Lordship, this very small petition.
No, have you seen the cause list? In half a day, around 2.5 hours, can you complete all this?
Lordship, otherwise,
Tomorrow.
tomorrow,
When did this someone receive?
tomorrow, someone has received, but tomorrow,
Why didn't you file it earlier? You should have filed earlier.
I filed 2 days back,
2 days back,
2 days back. but
not listed. When did you file? Give
no,
us
no,
the date.
there was some defect in the petition,
Then
so I,
you
so Lordship, this really urgent. Second summon, this is second summon. So otherwise they will issue this warrant.
We might, in principle, agree, but we may not have the
Warrant,
time.
Lordship, warrant is
We
going
may not
to,
have the time. Okay, try your luck.
Lordship,
Try your luck.
fileable.
May Your Lordship. Your Lordship, item number 13, Your Lordship.
1-3.
Yes, Your Lordship. May it be fixed on 18th of this of June, Your Lordship. I've taken the consent, Your Lordship.
On a matter made by Sri Solana State Council. Matter is adjourned to be listed
18th June.
on 18th of June.
Obliged, Lordship.
Amateur किया है तो ताते mention go like somebody. Yes, where is the council? Who has mentioned? What was his name?
Also, he was mentioning in code number 2, I was there,
Oh,
but the code number 2 said that make a mention before the code number 1 being a single judge. And it can be listed before. the
okay.
code number.
ताते हो if time permits, huh? Should not burden somebody else.
Okay.
Okay, you had mentioned before the other code, civil
No.
division.
No,
But
no,
that matter would be,
I tried there, but they've approached before the senior bench.
no, we have allowed in principle, but only if time permits. We cannot
Lots.
burden somebody
Lots,
else. We
lots.
can take the burden ourselves, but not to somebody else.
Avilash,
Yes,
I take to mention item number 3.
yes.
Sir, Arsigi has to leave this honorable court due to some personal difficulty.
Motion matter.
Yes, sir.
Why are you taking time in motion matters? What is the matter, subject matter?
Your Lordship, I don't have the preview, Lordship. As far as my, no, this is.
Tomorrow,
Apparently, this matter will be listed on Monday.
Monday.
My senior has leave, so no, because due to.
Okay. On a request made on behalf of Sri R. Sekia, Learned Counsel for the petitioners, matter is adjourned to be listed on Monday. Give the date, huh?
Lordship, I would like to mention for unlisted matter, Your Lordship.
Unlisted.
Yes, Your Lordship.
What is the urgency?
Actually, this matter is pending since 2022 only for this service report, Your Lordship.
Unlisted today is not possible for service report.
So
Have
may
it listed in the next week.
Yes, Your Lordship.
Unlisted is only for urgent matters, not for service report.
Yes, Your Lordship.
And give next week, next Tuesday.
Yes, Your Lordship.
Back to mention item number 15.
15.
Yes, my lord.
Yes, what is it?
1 week time may be granted for filing rejoinder against the counter affidavit filed by the government.
I have taken the consent. Have you taken you have to take the consent, don't make a mention of taking consent.
Not-
Take consent if they are around. Yes, Mr. Targum. Item 15, he is trying to take time.
1 week for for filing rejoinder.
All right. What is your name?
M. Atta, on behalf of Mark M. Kato.
Sri so Learned Counsel. Representing Sri so Learned Counsel for the petitioner has prayed for time to file rejoinder affidavit.
1 week time.
List after 2 weeks. To enable filing of rejoinder affidavit.
Obliged.
Sri T. Tagum, Learned
Training
Training Council Education is
Yes.
present.
Obliged.
May I please, Lordship, this is a contempt application, Lordship. The order is at page 61, Lordship. Page 61. And the relevant portion, Your Lordship, I take your Lordship to relevant portion is at page 63. It's a simple direction to dispose of the representation filed by the petitioner, Lordship. This is regarding compassionate appointment. So within a period of 3 months from the date of receipt of the certified copy of this order. Now this order copy was submitted, next page, Your Lord, 64, on 13/5/2024, Your Lordship itself. They have duly acknowledged the receipt. And for the director, also they have duly acknowledged the receipt at page 68.
Third, Sri A.K. Singh, Learned Counsel for the petitioner, who by means of this petition has alleged willful and deliberate disobedience of the order dated so-and-so, passing so-and-so. Full stop. The Learned Counsel has also drawn the attention of this court to the representation dated 6/2/2024.
26/4/23, Your Lordship.
No, what is the date?
26/4/2023. In the order, there is two date, but actually 26/4/23.
Representation dated.
Yes, Your Lordship.
What is the date after your signature?
Lordship,
What is the date after your signature in page 64? What is this date?
page 64. Yes, 26/4/2023.
This is 26. Where do you get
Yes,
26?
in the forwarding letter.
Huh?
In the forwarding letter of the annexures.
No.
Six.
The date appearing after your signature on the foot of page 64. What is the date? Page 64.
They have acknowledged receipt on
We are not
13/5.
on that, Mr. Singh.
Yes,
You have signed it while sending this. What is the date?
that is 6/2/20.
How can it be 6/2?
Yes.
The order is of 5.
So
What
I'm
is this?
sorry. 2/5/24 is the copy of the order.
That is what, how can you forward a 2/5 order by 6/2 letter?
No, that is the
Here's also, what is it? Here's also.
typography.
The representation which was received by the respondents on 13/5/2024.
Yes.
What's the para issue notice returnable by 4 weeks? Let steps be taken for service of notice upon the respondents by registered post to daily steps within 2 working days. Yes.
My lord, this pertains to non-compliance of the order dated 10/2/2025, my lord, which lordship will find it page 17 to 52, my lord. And the operative portion is at 51, my lord. Lordship got it?
50?
51, my lord. Para 23. A, B, C, D.
Yes.
E, N. May I read, my lord?
Just a minute. What was the time given? 3 months?
3 months, my lord. It's at
What is
page,
the order of the, what is the date of the order?
My lord, 8/10/2025.
10 to, okay, same order, huh? Where is your representation?
Represents my lord, it is page 53 to 59, my lord.
Okay, same order, huh? See, the judgment is dated, second the judgment. Ten to 2025, WPC 230 AP 2024, and representation dated 13 to 2025, okay? Okay. You take steps, we are issuing notice, register post today, within 2 working days.
My lord. That is fixed, my lord, returnable date.
4 weeks, 4 weeks.
Would it be 3 weeks, my lord? 3 weeks?
No, it has to go by registered post today, minimum 4
Obliged,
weeks is required, even for drawing presumption. Item 4. Yes, what is this?
My lord, this is my lord, I'm aggrieved by my lord to order the impugned technical bid evaluation dated 28 October 2024, as well as my lord financial bid evaluation, my lord. My lord, here, my lord,
Financial bids have been evaluated.
my lord has been evaluated, my lord. In the meantime, my lord, this
Order has been lettered.
my lord, order has been issued, my lord, in violation of this court order, my lord. My lord, earlier we had approached this court, my lord, in earlier round of litigation, my lord, where my lord, initially, my lord, it was order for retender, my lord.
No,
Because-
the earlier order was only pertaining to disposal of the representation.
Yes, my lord. In the my lord, earlier second round, in the second litigation, my lord, before, my lord, there was a status quo order was passed, my lord, till disposal, my lord. Now, without disposing the representation, my lord, they have awarded the,
Where is the status quo order?
my lord will see at initial order at page,
No, the final order, final order.
final order is page starting from 234.
Where
Portion at 240, my lord.
240?
Yes, my lord.
Interim order shall continue. Yes. Yes, what do you say? Tarak?
Without passing this, my lord, order, they have about.
So this order was passed in WPC one of the petitioner
Yes.
was the respondent private.
Yes, my lord.
So petitioner's representation was supposed to be not this present petitioner, earlier, the respondent hearing.
My lord, that is all right. It was a consensus order that on the condition that first you dispose of this sort, and on disposal, madam, we have been given liberty to challenge the order in an writ petition.
No,
When the-
where is your statement that the representation by the petitioners in the earlier case has not been disposed of?
My lord, we have stated, my lord.
Where? When can you get the instructions? Monday?
Monday.
We have this on for motion on Monday only on this issue.
Otherwise, my lord, this case, earlier the petitioner approached before this court, challenged the rejection of technical evaluation.
Correct.
Then the authority has decided to retender. Then that order was challenged by the respondent hearing.
Yes.
Then earlier order was reviewed by this honorable court. Then while disposing of the writ petition number 1 of 2025, this court has passed that respondent hearing the petition that writ petitioner has to submit a representation. Not the he who has to be submit the representation.
No, that is-
the one who has the award the work has to submit the representation. So till that there was status quo.
That is
So
why
he
that
might
was.
have submitted the representation and it was the
No.
work has been awarded.
My We have even moved.
No, what is your statement?
Malad, we have moved even.
No, where is the statement that in accordance with the order of 10/12/2024, representation by the petitioners in that case had filed had the representation is yet to be considered and disposed of.
Malad, at page 27, Malad. Para
20
11.1, Malad. Page 27 of the petition.
Yes.
Thus, petitioner was under bona fide impression that the authority shall maintain the status quo as directed by this honorable court. However, to the great surprise of the petitioner, without disposing of the representation dated, the chief engineer PMJS was illegally approved the financial bid of MS so-and-so by order. And
How have you verified this?
Malad, we have made an inquiry,
How have
Malad.
you verified this?
Malad,
How have you verified in your affidavit?
Malad.
How is paragraph 11.1 verified in the affidavit?
Malad, we have
These are factual assertion. You have to verify as per your knowledge. Where is the verification? Non-consideration of a representation cannot be a matter of record.
Malad, that's all right. Malad,
If it is all right, then we issue notice, short notice,
Malad.
and he'll take the instructions.
Malad, because we have already issued even.
Sri T. Tagum, learned counsel for the petitioner, who has put to challenge the bid evaluation report, part 1 dated 28/10/2024, pertaining to the technical bids of the petitioner in connection with a project for, please give the name of the project, huh? CO Road from MR so-and-so point Margarita. Huh? Basin of Obsidian. The learned counsel is also aggrieved by the evaluation done on the financial side. Amongst other grounds, it has been urged that in the earlier round of litigation, there was a direction from the court to consider the representation of the petitioner in that case. Until such time, no final decision was to be taken. Full stop, para. Sri Tarak, the learned standing counsel, RWD, on the other hand, has submitted that the stipulation for consideration and disposal of the representation pertained to the petitioner in that case, who is a respondent in the present writ petition, and therefore the contention advanced on behalf of the petitioner is prima facie not tenable in law. Correct? Be that as it may, let notice be issued, returnable on, we put a date. Today is 15. 15, 1, 2. We have it on 5th of June. 5th of June.
Malad.
But you take steps. Can you serve Dusty?
Malad.
Otherwise, 3 weeks. It will not.
Malad.
5th of June. Sri Tarak, the learned standing counsel, accepts notice on behalf of respondent numbers 1, 2,
5.
1, 2, 3, 4, and 5. Let extra copies be served upon him by tomorrow. Let steps be taken for service of notice upon the respondent number 6, 7, 8, 9, 10, and 11 by registered post with AD.
Malad.
Steps within 2 working days. Para. The learned counsel for the petitioner also seeks liberty to serve notice upon the private respondents by Dusty. Liberty is granted. Such Dusty is, however, required to be routed through the registry of this court, and in the notice accompanying the Dusty, the next date fixed, which is, what's the date? fourth, 5/6/2025 is to be reflected clearly. It is, the petitioner is also required to file an affidavit in proof of such justice before the next date fixed.
My lord. My lord, petitioner, it is undisputed. It is admitted that the land in question is the land of the petitioner, which was never donated nor acquired, my lord.
What is your grievance?
My grievance is, my lord has seen, my lord, may I take you to the annexure, my lord? Annexure 2, my lord, it will be clear now. This, my lord, there was a meeting, coordination meeting called by circle officer Takshing, my lord. This minor meeting, my lord, it says, my lord, says the land, the circle headquarters in Takshing, my lord, it
Your land has not been acquired.
not yet been acquired, my lord.
Yes.
That is the admitted position.
Government council, what do you say? Allegations are serious. That you have acquired his land, you have built a circle office.
Temporary, my lord.
It was already there.
Hmm?
He might have given this permission to construct it.
Okay, I heard Sri D come to learned counsel for the petitioner, who by means of this petition has challenged the taking over possession of the land which is under the possession of the petitioner since the time of his forefathers. It is submitted that a temporary office of the circle office taxing has also been constructed,
My lord.
without any authority.
My lord, there is permission for temporary, my lord.
Your without any consent
Yes, my
from
lord.
the petitioner,
Yes,
and his representation has also not been paid any heed to HWD heed. Let notice be issued, returnable by 4 weeks. Brisbane Solana State Council accepts notice on behalf of all the respondents. Let extra copy be served upon him by tomorrow.
My lord, the impugn order, my lord, is at page number 21, my lord.
What impugned order?
Impugn order is that, my lord, this order has been issued by the circle officer, my lord. My lord has seen this annexure 1, my lord.
Yes.
Whereby, my lord, it has been admitted that land was never acquired, my lord. Despite that, my lord, CEO Takshing, my lord, he has issued this order directing the executive engineer PWD to construct permanent structure in my land, my lord, by
No,
demolition.
this is only regarding dismantling of the temporary structure.
My lord.
How is this an impugned order?
My lord. It is not only that, confined to that, my lord.
Where?
In that place, my lord, they are planning to construct new permanent structure. my lord.
Where?
That is at, my lord. Type copy, para 2, my lord.
There are 2 years.
My lord,
Where is
para 1. An application was received from so and so, from the
Regarding
executive
this,
engineer
to
PWD.
execute.
Regarding this,
It will not be executed, it cannot be constructed within 4 weeks.
in order to execute construction of new.
The prayer for interim order will be considered under returnable.
My lord, otherwise, my lord, my suggestion would be that, my lord, let the counsel for the state respondent take instruction, my lord. Because, my lord, if this document is not disputed, my lord.
That is why notice has been issued.
My lord, only if this document is not disputed, my lord, this can be disposed of in the motion stage itself. So, my
No,
lord.
let him take instruction. Motion stage, we do not dispose of. We don't know what are the facts, whether it actually belongs to your forefather or not. Let him take the instruction.
My lord, till then, at least, my lord, since it has been admitted, my lord, that the land in question was never acquired, my lord. That is the
Where is
admitted
the
position.
admission? You are in motion stage.
No, my lord, admission on the part of the respondent, my lord.
Who is
The
it?
land-
By what? Has any affidavit been filed? Admission in a writ proceedings means admission by way of an affidavit. Not even his submission would, can be treated to be admission.
Since, my lord,
We have passed the order. Yes, next.
my lord, at least status quo, my lord, till then, my lord.
We have said we'll consider an interim prayer on the next date. What status quo? You don't want dismantling of the building, old building.
They can do that, my lord.
That is
But
only the.
my apprehension is that, my lord, after dismantling of the old building, they might
Let them
be,
construct in 4 weeks. Is it possible to construct a permanent building?
no,
Done. We'll give you a date list on, we'll give you a date.
my lord.
Today is what, 15th? 1, 2, 3, 4. We'll have it on 12th, on 11th, 11 June. 11 June.
My lord.
Please bring the instructions on 11 June. Yes. Yes, next. Yes.
May I please, Lordship? Lordship, here I am selling the transfer order, Lordship, which was issued on dated
Transfer order.
Lordship. Lordship, this transfer order was issued at the behest of a politician, Lordship. Without any public interest, Lordship. Lordship, may kindly come to page number 18 and 19.
How are you, where are you posted as, and what, as what are you posted?
Lordship, currently I am posted at SEPA as a senior
Sta-
superintendent, Lordship.
Station superintendent.
Yes, Lordship, at the Department of Transport,
Super, at SIPA.
Lordship.
Since when are you working in SIPA?
Since 2 years and 8 months, Lordship.
2 years, 8 months.
8 months.
Now transferred to
Transfer to GM office, Nahata,
25-4.
Lordship.
Nahalagan.
Nahata, Lordship.
In place of R4.
Lordship.
What are your grounds?
Lordship, may kindly come to page number 18, Lordship.
1-8.
Lordship, this is a prayer
Yes,
which was made to the Honorable Home Minister
yes.
to transfer me from SEPA to Nahalagan, Lordship. So may I read this content, Lordship?
Who had made this?
Lordship, this person is unknown to me. This is made by one Habring Taki, who is also unknown to me, and he is not related to department also, Lordship. This-
Is not available.
Apparently, Lordship, on the basis of this complaint only, this transfer has been effected, Lordship.
Yes,
Yes, Your Lordship.
what do you say?
Your Lordship, as per the transfer and posting guidelines, he has completed his 2-year tenure.
No, that is okay, but on the basis of an application by a third party, where he also mentions the private respondent,
This I have to take instructions. Your Lordship, in
you
this
don't,
matter.
you put this on halt, but has he joined?
Not yet, Lordship.
And Your Lordship, with regards to paragraph number 10, Your Lordship,
Yes, what is it?
he has stated that the normal tenure of posting of all the government posts at one place is 3 years, which is not, Your Lordship.
Okay.
It has been amended to 2
So that
years.
is okay, you can transfer him, but not on the basis of an application by somebody saying that he is mentally incapable, and so in his place he specifies somebody, bring him. This Tech Nicha is the private respondent.
Yes, Lordship.
What is your name? Your name, counsel?
Lordship, D. Saikya.
Heard Sri D. Sekar Leonard counsel for the petitioner who has put to challenge an order dated 25/4/2025 by which the petitioner, who is presently posted as station superintendent at SEPA, has been transferred to the office of the GM at Naharlagun, vice the respondent number 4. Para. It is the case of the petitioner that though he has completed 2 years, 8 months at SEPA, the impugned order has been passed on the basis of an application by a stranger who, however, had also requested for transferring the respondent number 4 in place of the petitioner, and such application was made to the Home Minister of the state. Full stop. The copy of the application which has been annexed as Annexure 3 also contains the endorsement by the concerned Minister of Home. Para. Sri Swenson London State Council has, on the other hand, submitted that the normal tenure after which a transfer can be made is 2 years.
Yes.
And the contention made by the petitioner in paragraph 10 that such tenure is 3 years is incorrect.
Yes.
Full stop. With regard to the other aspect of the matter pertaining to the basis of the transfer, the London State Council submits that some time may be granted to obtain instructions. Para. Let notice be issued, returnable on 30th of May. Give you a short date, 30th of May. Let extra copies of the writ petition be served upon Sri London State Council by tomorrow. Let steps be taken for service of notice upon the respondent number 4 by registered post with AD. Steps within 2 working days. Steps by tomorrow. Steps by tomorrow. Para. Sri Saikya, the Learned Council, raised for an interim order and has submitted that till date he has not handed over charge of the post. He has also submitted that a representation has been filed against the impugned order of transfer. Para. In view of the same and in the interest of justice, it is directed that till the next date fixed, status quo as on today may be maintained so far as posting of the petitioner is concerned. Full stop. Pendency of this writ petition shall not be a bar for consideration and disposal of the representation in accordance with law. Take steps immediately. Yes, Mr.
My lord, in this case, my lord, petitioner, my lord, they were placed under suspension on the 29 October 2022, my lord. Subsequently, that suspension was interfered with by this honorable court, my lord.
Okay.
Later, my lord, after as per direction of this honorable court, my lord, they were reinstated, my lord, on 20 October 2024, my lord. At page 25, at page, my lord, 61 to 64, my lord. My lord, although they have been reinstated, my lord, 61, but although they have been reinstated, but the arrear, my lord, whatever entitlement arrear, that has not been paid, my lord. So accordingly, they have submitted a representation to the authority, my lord, for considering for release of their entitlement, the arrear salary during the suspended period. Because similarly situated person, my lord, they have been given full salary of their suspended period, my lord. We'll
But
see
has the DP started against you?
my lord.
Has the DP been initiated against you?
My lord, till now they have not. lord.
But it will depend whether that period will be treated as on duty.
My lord,
If you are punished after the DP, then it will depend on the consequential order.
my lord,
Mr.
that
Kapil,
part,
what are you proposing?
So if I proposing lordship, are we allowed to take,
No, that is okay. We'll issue notice, but suspension was after some arrest.
no, my lord, no,
Pending-
no arrest, my lord, we were not involved in at all, my lord. This petitioner were never involved, my lord.
No,
Only
no,
they were,
suspension was in contemplation of a DP,
my lord.
or it was in a consequence of some arrest.
My lord, no arrest, my lord. It was for contemplating, my lord, saying that since there was an outcry, the public outcry, that's why, my lord, those who were posted in the,
When was the suspension?
my lord, suspension was on 29 October 2022, my lord.
22 suspension, were in 25. They have been.
My lord, they have
reinstated.
been, my lord, that has been revoked, my lord. Suspensions had been revoked, my lord.
That is, no, you have been reinstated pursuant to orders of the court.
My lord.
That will not absolve you from the liability that you cannot even be proceeded with. You can be proceeded with.
My lord, in similar situated, my lord,
Third
they have been released with all full payment, my lord, under similar situated case, my lord.
that is, I have seen that.
Third Street Tagum Learned Council for the petitioners. It is the case of the petitioners that they were placed under suspension by the order dated 29/10/2022, which was, however, the subject matter of challenge in writ proceeding before this court, and in terms of an order passed by this court, they have been reinstated. However, till now, no DP, no disciplinary proceeding has been initiated against them, and the period of suspension and the salaries, public allowance for the period of suspension have not been released. Farah. It is also contended that similarly situated persons have contended that for similarly situated persons, the arrear salaries have been released. Farah. Let notice be issued, returnable on 9th of June. 9th of June. Yes, Tapin. Learned Senior Advocate accepts notice on behalf of 1, 2, 3, 4. 1, 2, 3, and 5.
Lordship, I'm
APPSC, what is your name?
Lordship came in, Lordship, on behalf of Sri Apang, Lordship.
Okay, Learned Council, appearing on instruction of Sri Apang, Senior Council, accepts notice on behalf of Restaurant 5 APPSC. Extra copies by tomorrow, huh? Write the full line, huh? That extra copies be served by tomorrow. You get instructions if you have paid to others. Let them. Yes.
It's,
What is this?
Lordship, in this case, the petitioners are petty businessmen who are earning their income by doing small businesses. Now, in order to earn their livelihood, they obtain one permission from the Deputy Commissioner Pasigat to conduct one Mela. That is in page number 12, Your Lordship, the permission that page number 12.
Yes.
Yes. May I read the permission, Your Lordship?
Mela, what do you do?
Mela.
Mela?
That
Lottery?
no.
Housey?
No, that all those Mela, page number
In
15.
the name of Mela, what do you do? Tell us.
You kindly go to page number 15. That I have a photograph of that Mela, the usual Mela, that all those giant wheels and
Pasigat is very famous for Mela, we know.
this kind of
What
Mela.
happens in Mela?
No, the other, Your Lordship, this usual Mela.
Usual?
Yes.
Usually that happens.
No, this with all these giant wheels and the child's play, all these things.
Huh? Child's play.
Yes, where they used to buy this page 15.
Well, how much is the prize money? How many crores?
No money, Your Lordship.
How much is the prize money? We know a bit of Mela in Pasigat. It goes to crores. For one ticket, how much is the charge for one ticket?
No, Your Lordship. There is no ticket, no money is charged for the entry fee. It is free entry, and just for the,
Not free and not for the entry. For the actual game.
For all these games, we used to charge 50 rupees or 100 rupees for all these games for like.
We are not on those games. There are different games.
Then, yes.
Yes, yes, what do you say?
So this was the,
When do you propose to have the Mela?
Your Worship.
When do you propose to have the Mela?
No, I was, the permission was already given to me.
No, when do you propose to have? Now this order has been passed on 2nd of May.
Yes,
When was the Mela supposed to be held?
it was already in functioning. After obtaining the permission, we installed the melas. I contacted the person from the outside.
But then you have to issue notice. Yes.
Now,
Heard Sri so learned counsel for the,
Your Worship, my prayer is that kindly allow me to function my mela in the meanwhile, because my whole mela is in standby, and I'm suffering loss on daily basis, Your Worship.
we'll give you a returnable date. So I have so learned counsel for the petitioners, who are aggrieved by an order dated
2nd May.
2nd of May 2025, issued by the district magistrate, East Siang District, Pasighat, by prohibiting holding of weekly market / Mela full stop. It is submitted that the Mela / weekly market which are conducted by the petitioners
Your Worship,
have been done by following the due process of law and with permission. Full stop. Para. A perusal of the impugned order does not reveal any reasons for issuance of the same. Para. Let notice be issued. Returnable on.
Your
We
Worship,
give you a short date.
19, Your Worship. 19 of this month, 19 May.
Today.
Today-
So how can he get interest we'll have it on 22nd,
No, then after 25th then.
26th. Okay, returnable on 27th, May 2025.
Your Worship, kindly my prayer may be considered because my whole mela is in
Yes,
standby.
with Sri so learned State Council accepts notice on behalf of all the respondents. Para, let extra copies be served upon him by tomorrow. Para, the so learned counsel for the petitioner prays for an interim order. Para, the aforesaid interim order, the aforesaid prayer would be considered on the returnable date. You come up with instructions. There are no reasons are there. Why have you stopped?
actually that was the decision of the government.
No, you
Not
have-
only
there-
Pasighat, but entire this ownership process.
There has to be some certain reasons.
There must be some reasons, yes.
I'm only on respect of mela, Your Worship, not other weekly markets.
9. Mr. Tafu, what is this?
Yes, ma'am. My lord, the petitioner was working in the DRDA, my lord, and retired in 31st May 2018, my lord.
18.
Yes. Now, my lord, by page 26, my lord, by order dated 22nd February 2024, my lord, the DRDA has been discontinued, my lord, in 2020 by the central government, ma'am.
When
And-
discontinued?
In 2020 central government, my lord,
2020,
21.
21.
Yes, my lord, by this order dated Annexure 6, my lord.
Okay, thereafter.
All the employees were taken into rural development department.
Hmm.
Altogether, 588 people were my lord, taken to RD department, rural
Yes.
development department.
Yes.
So there are persons I have indicated, my lord, in the list, 12
Now, what is
persons.
your grievance?
So my grievance is that I should also be, my lord, included, so that I will have the pensionary benefits on, nothing else, my lord.
But you had your ties with the DRD was severed when DRD was existing in 2018.
No, that's by this
The
order.
decision to merge or dismantle came in 2021.
Yes, my lord.
How do you get the benefit of?
No,
the
my
pension?
lord, by this order, my lord, the people who have retired before this order, they were also included, ma'am. That's why I'm praying the
Okay.
similar benefit may be
First,
given to.
Peter for learned counsel for the petitioner. Full stop. It is the case of the petitioner that on 31/5/2018, he
had gone on voluntary retirement
Yes.
from the DRDA Dibang. Full stop. However, subsequently, in the year 2021, the DRDA was discontinued and the functions were taken over by the Rural Development Department.
Yes.
It is the grievance of the petitioner that by an order dated 22/2/2024, the name of the petitioner has been excluded from the list of persons absolved, and thereby he has been deprived from pensionary benefits.
Yes.
Para. On the other hand, Sri B. Picha, Learned Standing Council, Rural Development Department, has submitted that the impugned order is much subsequent to the date when the petitioner had severed his ties
Right.
from the erstwhile DRDA,
Right.
and therefore there is no employer-employee relationship
Right.
of the petitioner with the Rural Development Department. Full stop. He accordingly submits that the present claim is not even maintainable.
Yes.
Para?
Yes.
Let notice be issued, returnable by 6 weeks. Sri Picha, the Learned Standing Council, accepts notice on behalf of the respondents that extra copies be served upon him by tomorrow.
Yes, ma'am.
Obliged.
Item number 10.
Mayor, to your lordship.
Yes.
This is an offshoot of another pending writ petition. Matter relates to an action on the part of the collector, my lord, not to give us compensation. Land was acquired, my lord, for Italian hydroelectric project, Divangbeli.
Okay.
Now, these three unfortunate petitioners who are female, on the ground that they are female legal heir and the parents did not have any male legal heir, they are sought to be deprived of their compensation. This is very unheard of. If a parent,
Where is that finding?
my lord, that finding is there, my lord. Now in the main writ petition, this honorable court has already issued notice and directed that representation which they have filed, that should be disposed of. That has been impugned in this case. Lordship will find at page, my lord, 28.
Wait.
Page 28, my lord. Here they have, your lordship is aware of the land acquisition proceedings. This has been, representation has been rejected only on the ground that when section 9 notice was given, they did not file any claim. But the main question as to whether being female, they can be deprived of their right to get the compensation has not been decided, my lord.
But that is not discernible from 28, page 28 order.
Well, page 20 order, if your lordship reads, my lord, lordship will find.
Where is that consideration that only because you are female heirs?
That your lordship will kindly take up item, my lord, 37. There it is there, my lord. Same is 37, my lord. 37, my lord.
But your matter has come up for motion.
These both are connected. In the main case, this one court directed that representation should be disposed of. So they have disposed of rejecting our representation.
No, we have understood. Now, in the present case, you are aggrieved by 16/4/2025 order.
Yes,
by
madam.
which your representation has been disposed of.
Rejected, yes.
While the representation has been disposed of, there is no consideration of any female heir. So how does that become a cause of action?
That becomes because here it has been rejected only on the ground that while section 9 notice was issued.
Sri D. Mazumdar, Learned Standing Council, who has appeared online with the assistance of Sri P. Bora.
My lord.
Mr. Mao is appearing.
Mao is there, my lord. Yes,
So
Mao.
S. Mao. Full stop. The petitioner has put to challenge petitioners, it does.
My lord, three petitioners.
Have put to challenge an order dated
16/4/25.
16/4/2025
My lord.
passed by the
Deputy Commissioner.
Deputy Commissioner Dibang Valley,
My lord.
whereby the claim for compensation has been rejected. Full stop.
My lord.
The Learned Standing Council has submitted that the petitioners had earlier approached this court by filing WPC 167 of 2024, which was disposed of.
No, my lord, that
No,
is
in which
pending.
an order- in which an order was passed on 2/4/2025,
My lord.
directing for submission of a representation. And by the present impugned order, the representation has been rejected. Correct?
My lord.
Let notice be issued, returnable by 4 weeks.
I will be appearing for private number 4 to 8.
And yes, Priya Stapin,
1 to 3.
learned senior advocate accepts notice on behalf of respondents 1, 2,
One
and
to three.
3. Sri Saxena, learned counsel has entered appearance for respondents 4
to 8.
to 8. Let extra copies of the writ petition be served upon the learned counsel for the respondents by tomorrow. List along with WPC
167. my lord.
167 of 2024.
167 of 2024.
My lord.
2025,
24.
24.
24. my lord.
This is a shorter date closing, after 2 weeks closing, since parties are already appearing.
We are not
Can I
passing
be
an
on-
interim order.
No. After 2 weeks closing.
Oh, what did we say? Returnable?
My lord, 27th,
That would be
if
issued.
your lordship.
Returnable 4 weeks, we had said.
2 weeks.
We had said returnable by 2 weeks.
Lordship, can it be on 27th, my lord, if your lordship?
We can have
No,
27th is
No issue.
last minute. As requested, list on 27.
My lord. Deeply applied.
Well, challenging the reversion order, my lord. This is
Reversion from?
from block education officer to TGT. Although the post is analogous, but the block education officer is a gazetted post, my lord. And my lord, the same, this is.
Reversion is after a disciplinary proceeding.
No, my lord, no. My lord, here,
What are the grounds cited for reversion?
the ground is that the DPC has not been conducted, my lord. Because their case, my lord, the fact is, my lord, the 114 posts of TGT were converted to the BEOs. There is a cabinet decision, and in compliance with the Honorable High Court order only, in all the orders of the regularizations, everything they have mentioned the Honorable High Court's order. And thereafter, suddenly, they issues a show cause notice and then this. My lord, in read petition number, my lord, 200, by order dated 6/5/2025 has already been stayed. This remaining petition.
Yes, Mr. Tagum, stayed.
My lord, this is stayed, my lord. My lord, this fixed on 26, my lord. My lord, I short for instruction on 26.
Heard. Sri T.T. Tara, learned counsel for the petitioners who are aggrieved by the impugned order by which they have been reverted from the post of block education officer
Education officer, my lord.
to the post of trained graduate teacher,
Teachers.
within bracket TGT. Full stop. It is submitted that though the scales of both the posts are the same, the post of BEO is a gazetted post. Full stop. It is also the case of the petitioners that no disciplinary proceedings was initiated, and on trivial grounds, the impugned order has been passed. The learned counsel has also drawn the attention of this court to an order dated 6/5/2025 passed by this court in WPC 200 of 2025, in which, in a similar matter, this court had also passed an interim order. That notice be issued, returnable on
26
That
May.
notice be issued, don't say anything. Sri T. Tagum, learned standing counsel, Education Department accepts notice on behalf of all the respondents. Let extra copies be served upon him by tomorrow. Sri Tara, the learned counsel for the petitioners, prays for an interim order, and as reflected above, he had referred to an earlier order passed by this court in an analogous petition. Considering the above, it is submitted that till the returnable date, the impugned order
11-4.
dated so and so shall remain suspended. Para. Let this case be listed. The returnable case is fixed on
26 May 2000.
26 May 2025, on which date WPC so and so is also slated to be listed as LAPED. You knew the repetition number, no? 200. What was the repetition? 200.
200.
200 of 2025.
2025.
Okay.
DPO.
Yes.
My pleasure, Lordship.
Yes.
Lordship, in this writ petition, Lordship, I'm being aggrieved by the order of the Deputy Commissioner, who is acting as the appellate court, has passed this impugned order, Lordship, without according any opportunity of being heard, Lordship. Lordship, there was a order from this honorable court.
Pleadings have been exchanged.
Lordship, yes.
Yes, what do you say?
So I have misplaced my
Huh?
Lordship.
Are you ready for a disposal today, or we can have it when? Tomorrow or Monday? If
Monday.
pleadings are exchanged, we can have it. I don't think, matter of which year.
Lordship,
21. Why should we?
Monday,
this-
Monday.
Monday?
Monday, Your Lordship, Wednesday, Your Lordship.
Wednesday.
Then
Monday,
Tuesday.
I'll be out of station. Your
Tuesday?
Lordship. Monday and Tuesday, I'll be out of station.
Okay,
Your
we'll try on Wednesday then, okay? Pleadings have been exchanged and the learned counsel for the parties have come to a consensus that the matter can be taken up for final disposal at the admission stage itself. Sarah? Accordingly, list for admission hearing on Wednesday. Give the date, huh?
Obliged.
Wednesday will be what date? 21. Mr. Kato, what is this?
This is tender matter, madam. And madam, I am informed, madam, Arish Nabam, madam, owing to health issue, madam, he is left the court premises.
Yes,
Madam, matter may
Then
be.
Monday? Otherwise, you have filed affidavit, madam?
Yes, madam.
we have filed.
Everything is done, madam.
Then when can
Madam,
we have?
madam, on 20, madam. As con-
20?
20, madam, as concentrated by the other party, madam. It
Tuesday.
is very simple, madam.
Tuesday?
Tuesday, madam.
Okay. Heard Sri M. Kato, learned counsel for the petitioner. But however, Ms. Pangu, the learned state counsel, has prayed for a short accommodation on behalf of Sri R. H. Nabam, learned AG. Correct? As agreed upon, list on
20, madam. Tuesday,
20
madam. Much obliged.
for admission.
Madam.
16.
Yes. My lord, the case involved is on a closed parameter, my lord. The respondent was appointed as a.
R4 appointed? No.
Yeah, no, respondent,
R4, who is R4? You have R4?
yes.
Yes.
Thereafter, my lord, what had happened is. Thereafter, he went on deputation.
He was?
He was appointed in his initial entry to the government job as
Who
a junior
responded?
engineer. Yes, he is in the PWD department. Similarly, the
Respondent number 4.
yes, respondent number
R4
4.
initially in PWD. Initially in PWD.
PWD.
Then
Thereafter, my lord, went on deputation to the PWD. This urban development department.
Urban
yes.
Development Department.
Yes.
RDD.
RD.
Or UDD.
Yes, my lord.
UDD.
So thereafter, UD, Urban Development Department, my lord, thereafter, what had happened is he interpolated the A's at the belated stage.
Response number 4 interpolated age,
interpolated the age,
date of birth.
date of birth and all, my lord. So then thereafter, what had happened was, my lord, just accommodate me 1 minute, my lord, just.
Yes, yes.
So then, my lord, the fact is in 2000, my lord, it came to be detected when the inter se seniority list was published by the
You are working in the UDD
UDD
as
now executive engineer.
okay. Then inter-seniority list was prepared.
Inter se seniority list was prepared on 21/8/2014. From there, the petitioner came to know that the private respondent number 4 has interpolated the age at a belated stage. my lord.
Okay.
It is a settled position of law within a 5 years period is the gestation period to correct the age. And government affidavit also says, but then later on they have done so much of thing, my lord. It is, my lord, his initial appointment in the PWD was 25/9/1992. And his date of birth was recorded on 14/12/1961. And the retirement date was supposed to be on 14/12/2021.
Yes.
Then what had happened was, however, after joining the Urban Development Department as an urban project officer by order dated 16/7/2002, my lord, his date of birth has been interpolated to 14/3/1966. Now, my lord, I'll seek the indulgence of my lord to page 20, my lord, that's annexure 1. The appointment of the private respondent number 4, my lord. This by order dated 16 July 2002, my lord.
Yes.
Annexure 1,
Page?
page 20, my lord.
Type
21 is type copy, my lord. As an urban project officer.
Who's this? This pertains to the private respondent.
A private respondent.
R4, what is his name?
Is Taban Tabing.
R4.
Serial number 1. Serial number
R4.
R4 serial number 1. Then my lord will kindly come to page 22, annexure 2, my lord. Type copy is at page 25, my lord.
Yes.
My lord will find the interpolation of age at serial number 10, my lord, T Tabing. Column 3, my lord, will see date of birth 14/12/1961.
Column?
Column 3, my lord. Column 1, 2, 3, 4, my lord. Date of birth, my lord.
Yes.
My lord,
Where is he?
He is at serial number 10, my lord.
R4.
Yes, ma'am.
Date of birth.
Date of birth
61.
14/12/1961. That my
Yes.
lord had noted. Then my lord will kindly come. Now, how this interpolation was detected is this at page 26, my lord. Annexure 3 series, my lord.
Page?
Page 26, my lord. Annexure 3 series, my lord.
Provisional seniority list.
of the PWD. Here, once this was published, from there we came to know that his original date of birth was something else. Malad, the serial number will find at page 31, Malad.
31.
31, Dagway. Page 31, Malad will find at serial number 446.
Yes.
There, my lord will see the his original record of joining in the PWD department. His date of birth was recorded on 14/12/1961.
Correct.
Yes. So here the problem has started, my lord. Now, my lord, kindly come. Then thereafter, annexure 4, my lord, page 36. This is the provisional seniority list of executive engineers.
Yes.
Then my lord will see at serial number 3.
Page?
Page 36, my lord.
Yes.
Here, my lord will see date of birth, column number 3, serial number 4, column number 3, Sri Tabing. His date of birth is recorded as 14/03/1966.
Yes.
Then thereafter, my lord, we have the petitioner have submitted the representation at page 38, raising that there is an interpolation of date of birth beyond the rules, my lord.
Yes.
Well, we'll see this. We have written to the Commissioner, Department of UD and Housing here on 7/5/2024, my lord. We have raised all the ground and all the relevant, my lord, rules and citations of the Apex Court has also been quoted in this, my lord.
Now, what is their stand?
Now they say that initially when he was in the PWD department, they could not, there was a move, but the government have rejected his request. It has belated stage. The file noting is very clear, my lord. Then thereafter, my lord, now they have, after so many years, my lord, 13 years, joining in the UD department, has gone to the Ajmer, corrected his date of birth, got a class 10 certificate from there. And this is already barred by the law of delay and laches, my lord. So therefore, in their affidavit also, my lord, they have clearly said that there was a denial at the first instance, and second instance when there was a affidavit from they have executed one affidavit before the judicial magistrate, Ying Kyong. And then this is the date of birth, and thereafter the course they have taken, and then they went up to, my lord, Ajmer. And thereafter, new class 10 certificate was produced. That is my case. Because of this interpolation of the age, my lord, 4 years additional service. Otherwise, he ought to have been retired in 2021. And because of his interpolation of the age in the service book, my lord, my right for promotion as a superintendent engineering is being violated. Therefore, my lord, calls for the, and then law I will place, let my friends submit to what they say.
Now, how is his, how are you espousing his cause? What relief are you praying?
My prayers are on 2 counts, my lord.
Are you praying for any quo warranto? What read are
No,
you
my
praying
lord,
for?
what we are saying is to institute an inquiry against him. Why this interpolation, how this
No,
interpolation of
how are you, first you have to say, so how are your rights affected? If your rights are not affected, then you have to pray for a writ of quo warranto. That is not there.
My lord, I have made a categorical statement. Kindly come to para 8, my lord, of my writ petition.
What is there?
That I said he is just placed above me. Above me.
Yes.
Because of this interpolation of age, I will not get the promotion. He will get the promotion.
No, see, Mr. Tara,
My lord.
there are 2 things. Once you use the expression interpolation, there is an illegality.
Illegalities.
Now, once you say the date of births have changed in accordance with law, that can be possible. And so far as your submission is there, concerned that at the fag end, it is not permissible.
Not
This is
permissible.
not for it's a caveat for the courts. That if you apply for change of date of birth at the fag end and it is rejected, then courts will be very reluctant to give you relief. But here is the case where the authorities have exercised their powers. In that exercise, how do you find fault? Fault has to be apparent on the face of it.
There, what I am arguing.
Yes,
Malad,
what have you done, Mr. Ratan?
Not, as per records, in fact, he had initiated for correction of his name, age,
While in PWD?
while in PWD.
Oh, that was rejected.
Not rejected, that could not be, come to a logical end, Malad. So he pursued again after the deputation to UD. And that, in the file noting also, it was
When was it first moved? When was it first mooted to correct the date of birth, even assuming that there was a?
it is, my lord, from the PWD, there is no affidavit, but the private respondent, they have shown, my lord, that it was initiated in the erstwhile PWD.
When?
1993.
93?
Yes.
What is the record?
At page 112. This is to the Superintendent Engineer, Alo Circle, PWD, Alo. Declaration of date of birth in respect of Sri Taban Taban JE. With reference to your letter quoted above, it is requested to ask Sri Taban Taban JE to correct the date of birth in school certificate by the Board of Education, providing the documentary evidence and resubmit the same to this office for further action, please. He initiated, at page 109 is the affidavit shown.
After 8 years, the process.
Yes, yes, in UD.
In UD, yes. Was turned down. Yeah, it was.
This what is 111? That is the corrected date of birth or what?
111.
111?
No, this is the, yes, corrected
Date of birth?
by the.
This is by the appropriate authority.
No, yes, economics and statistics.
Yes, is the registrar of the births and deaths.
Yes, but in the class 10 certificate, it was.
But this was done in 1993 itself.
93.
Move was there, Mr. Tara. 1993 onward, move was there.
Move was there.
And there is an original certificate issued by the appropriate authority, namely the Registrars of Births and Deaths at page 111, 14/3/1966.
That is discernible, my lord. In the file noting, it is clearly reflected that initial move was rejected because of
Where?
page, my lord, in his affidavit, kindly come to page 63.
63.
Yes.
Para?
My lord, this serial number 94 type copy, the file note. As per matriculation
No,
certificate.
no, you have to give me the serial number of the page.
No, it's 63, my lord.
63 is the part of the buildings.
Yes.
No, no, you have to say 63, you have to give the continuous page marking.
Yeah. Yes, my lord.
Continuous page marking, it starts with page 50.
Yes, my lord.
Additional affidavit.
Additional,
In 63.
63, my lord.
63, we have
No.
readings
Our
only.
affidavit. No, affidavit in opposition. It is my affidavit in opposition. File notice.
No, I have to give us,
Yeah.
give us the,
So I apologize, my lord.
no, no, then what
Our
difficult.
affidavit in opposition was filed.
You are referring to what? Affidavit in replies?
This is, affidavit in opposition of respondent number 1 and 3
1 and 3.
by Mr. Ratan's affidavit.
Okay, which annexure?
Annexure A and B, my lord.
A and B,
Yeah,
okay.
it
This is-
starts from page number 63.
No, this is the 66 here. A and B,
63.
66, okay.
63 is relevant for me, my lord.
No, your pages are not matching, that is why. So, which one? Serial number?
94. My lord will see typed out copy, the file noting.
94. Yes, as per matriculation.
Yes, ma'am. As per matriculation certificate, date of birth recorded on 14/12/1961. There is no birth certificate record from Register of Birth and Death. Entry has been made in service book accordingly during 1992 in his first appointment to service. It is now after 14 years of service, often is requesting for alteration. A record of AISSC in his education is tally with the recorded in his service book.
Yes,
There is a file noting, my lord.
yes.
Then,
As per permission.
yes, then thereafter, my lord, he says in page 64, the
No, no,
record-
what is the last line?
Huh.
Last line, last
Yes.
line.
As per permission of date of birth and its subsequent alteration, page 16/6 for rule 3, normal requests made within a year or two of the date of superannuation are not continuous, not, that is not permit or not.
No, no, but that was not under 2 years or 3 years of his subordination. This was in 2007. This file noting
Yes,
was of 2007.
that's why, my lord, after 14 years, the file noting by the undersecretary has clearly revealed the fact, saying that after 14 years, again, he has reprocessed the file. So therefore, my lord, that is not an automatic right, entails him to claim for correction of the age at the belated stage, my lord. And even in his own that GFR, he has quoted, my lord. So rule also he has quoted. In his affidavit only it is there, my lord. Is it? My lord, kindly come to page 59 for a moment. Annexure A, my lord. What the rule says on how date of birth can be corrected, my lord.
Yes.
Page 59, my lord, kindly come to para 3, serial number 3, date of birth and its subsequent alterations. This is Swami's handbook compilation, my lord. It's a government affidavit, my lord. Declaration of date of birth. Every new entrant to government service should declare his date of birth by the Christian era at the time of the initial appointment with documentary evidence, viz. Matriculation certificate, municipal birth certificate. In the absence of such proof, he may declare approximate age or year or month and year of birth. Assumed date of birth will be arrived at as under. One, if the approximate age is declared, the number of years representing the age declared to be deducted and assumed date arrival at Malad. Now, if year of birth only is declared.
Now you come to subsection 3.
Yes, subsection 3, yes, sir.
Subsequent alteration, that is.
An employee makes a request disregard within 5 years of his entry into government service. This is what I was, in the Karnataka judgment also.
No, he had made the move in 93. He entered into services 91.
But in page 64, in para 94 of the file noting, it is clearly reflected. His initial matriculation certificate and date of birth were telling. The first move, in terms of that file noting, it is clearly revealed that initially his date of birth certificate and matriculation certificate is matching. 1961 as a date of birth. Now it says after 14 years, again have approached before the authorities. So therefore, that subsection 3 subclauses covers. At the belated stage, anything can be done. A person can reach up to Ajmer to collect the new matriculation certificate. 14 plus 8 after 22 years.
Who was in Ajmer?
Ajmer, the Central Board of Secondary Education headquarters used to be there at that relevant point of time. Now we have a regional system. We have a Guwahati, Delhi region, and also and so forth, Malad. Malad, even in page 52 of the government affidavit, 51 para 3, I will rely on this 2 paragraph further.
What do you call this rule 3?
Yes, Malad. Thankfully, the department has come up of very honestly, Malad. The government affidavit, if my lord allows me to read.
But how do you overcome the 93 initiation? This note, no doubt, is of 1990. 2007, but there are materials on record that in the year 1993, that is within 2 years from his joining his service, there was a move to correct the date of birth.
Then, my lord, thereafter this file was moved, my lord will see in their own affidavit only. Page, 1 second. My lord will kindly come to page 64 for a moment, the government affidavit.
Page numbers are not, you have to say something else.
64 of the
No, no, 64 will not help us. Paginations are different. You have not paginated in accordance with the court records. What are you referring? Government affidavit, which paragraph?
Well, the representation submitted by the respondent number 4, private.
Annexure?
Annexure C of the government affidavit,
C.
page 64.
No, 71.
Yes.
Not 64, 71. Okay.
Then, my lord, kindly see the date of filing application before the chief engineer cum director urban development was on 5/01/2015.
Now, first, see the reference. You will be in a soup if you are referring to this. See the reference, my earlier representation number so and so, so and so, so and so, he gives a number also. 31/5/1993.
No, my lord, I am not suppressing anything, just I am
No,
rather
it's not a
assisting.
question of suppressing. see, this representation refers to a move of 1993. He also gives the file number, representation number.
My lord, to be very fair, let us ask ourselves. Once your first move was rejected 8 years ago, and thereafter, after 14 years, you initiate, my lord. This is the question that I myself is asking myself. Can such action be permeable? My lord, again, the note starts from page 68. And that firstly, my lord, first rejection order was not challenged. When his first move, although he has referred this 1993 move, it was rejected by the government. And that rejection.
Where is the rejection?
My lord, will page 68. My lord. Then second, second, देखो तो alteration of NOC from approval. No, 1 second. There was.
Where is the order?
No, it is in my documents, my lord. Government affidavit, my lord. No. My lord. It was turned down in the file, my lord.
No, where is there any order?
And there is no order, my lord. That is not a compliance of 166 clause 3, my lord, unless it is not communicated. So that I sit here, my lord.
No
I
order.
cannot travel beyond this also. But my lord, only the issue for adjudication before my lord is the first thing, although it is not, my lord, that Pimpri's judgment will come into, my lord, here. Unless if it is not communicated, it will not be a compliance of Article 166 subclause sub-article 3, my lord. Officially, they have rejected his first move. Then thereafter, my lord, what happens is, it is down the line, 14 years, much water has flown.
But the rejection is not communicated to him.
Not communicated. Fair, very fair, my lord. Because although, my lord, I am representing my client, and at the same time, I have to assess the court, what is in their conveniences, my lord, and the balances, my lord. I cannot travel anything beyond the records.
No, first you have not prayed for the appropriate writ. There is no prayer for writ of quo warranto. You have to ask by what authority are you continuing after completing 60 years? You have not asked that question.
My lord, I understand, my lord. However, my lord, at the same time, my lord, there is only a prayer which says that mandamus should not be issued directing respondent to initiate inquiry to unearth the truth behind the interpolation of date of birth, my lord. That is one thing, my lord. Then mandamus should not be issued directing the state respondent.
No, as on presentation of the writ petition, this kind of relief writ for may be impressive, but once they have disclosed everything, that is not interpolation. They have done certain action, whether it's a legally permissible action or not. Interpolation will have different ramification.
Correct.
Interpolation is illegality, known illegality. Malafide would be involved, but here, yes. Anything else we will ask them?
Before my brothers, they start their argument, my lord, kindly give me 1 week time. I'll seek instruction from my client. 1 week time.
We had almost heard the matter.
Kindly.
For what?
I'll seek one thing, whether he wants to pursue this, because this man is retiring also this year. His transfer order was already state, I think status quo.
Who's
something?
Your client?
No, this private respondent. Well, just give me 1 week time, my lord. I'll come back with the instructions.
You should have told at beginning. Should not have wasted so much of.
I apologize, my lord, for the inconveniences.
You just change your stand like this. Heard Sri Tara, Sri Tara learned counsel for the petitioner. Also heard Sri N. Ratan, learned AAG. As well as Sri Parme, L permit for the private response number 4, full stop. After advancing the arguments at some length, comma, the learned counsel for the petitioner, Sri Tara, has paid for a week's time to obtain instructions. Para, list after a week's. List
Great,
after a
sir.
week.
Let it be then after 3 weeks, man.
No, 1 week only. In the meantime, if my client says don't pursue, I'll come and we'll wait.
Hmm? 2
Yes.
weeks. Please for some time to obtain instructions. List after 2 weeks.
Fine, fine.
Nineteen.
My lord, last occasion I was supposed to file affidavit in opposition.
Yes.
So now matter affidavit in opposition is before the law betting. So it's-
Okay. We'll grant some more time?
yes.
Okay.
Maybe please after 2 week lordship.
2 weeks.
Yes.
You
And
file it within 2 weeks.
Yes,
sir.
yes.
and
Sri G. Tarak, Learned Standing Council, RWD submits that the affidavit in opposition has been sent for waiting and will be filed shortly. Full stop, para. List after 2 weeks to enable filing of affidavit in opposition by the department.
Okay.
Deviate lordship.
I just, that the matter was heard by your lordship. My lord, which I showed before your lordship, 3 documents at page 257, 266 and 269. Because there was, my learned friend Ratan has.
Into collision. Yes, well, can we just recapitulate what was your
Yes,
case?
my lord, these petitioners before your lordships, my lord, were holding this land and they were.
How many of you are there?
My lord, there are few numbers for this court because this has been represented by a power of attorney holder. And the power of attorney is here, my lord. I have annexed the power of attorney from page
Okay.
33
It doesn't matter.
onwards, yes.
One person is espousing the cause of the other.
Yes, correct, my lord. That's all. And my lord, there were several representation before the authority, before coming to the court, saying that these are the lands about regarding 97 point some hectares of land. Total was 1545 hectares of land. Out of that, 97 point,
96 point.
yes, 96.977 hectares is an USF area, which belongs to the petitioners. And rest 48.433 hectares is reserve forest. If you plus this, it comes to 145 hectares. 145 hectares. And these lands have been occupied by the ITB. And since 2005, they were occupying and neither it has not been acquired by the state government, neither any lease rental has been paid to us from 2005 onwards. So that is why what our prayer before this court that you kindly acquire this land by way of notification or
what you can do is, please pay our rental from the day from 2005 onwards. Till the date you occupy, or either you hand over to us. Till the date. So now, my lord, we made an RTI before the authority, because their whole case is that entire land, 145 hectares, they said that already it has been taken, allotted to ITB. That was their stand. And some compensation has been paid. Now, on the last occasion, I showed before this court that this land has not been allotted to ITB. How I'll show how it is not yet been allotted. Your lordship will kindly see at page 257. 257. We made an RTI. 257. First, we wanted to know from there regarding the two plots of land. Kindly see, my lord, at page 257, where the district land revenue settlement officer has replied us. 1. Details pertaining to the two plots of land measuring 318.30 acres, 41 acres of land under the occupation ITB at Teju. So now, my lord, if 318.30 acres plus 41, it comes to 145 hectares. If you plus this. And if you look, lordship, kindly see on the left-hand side, right-hand side of the column, it is state that the land under occupation ITB at Lohitpur is not allotted to the user agency as on date. A copy of the last correspondence made to Director LM and Assam Rev enclosed herein for your kind information. So this is 12th of February 2024.
Now this, Mr. Das, the query which you had put under the RTI,
yes,
we're seeking the details of two plots of land.
Yes.
One is 318.30 acres and the other is 41 acres.
Yes.
Now, both these lands were said to be under the occupation of the ITBP at Teju.
Correct.
Now, the answer which has been given on the right side,
yes,
it is stated that the land under occupation of ITBP at Lohitpur
yes,
is not allotted to the user agency. Now, which is the Lohitpur area?
Yes, my lord.
Is the entire area Lohitpur?
No, kindly see this, my lord. If your lordship kindly see at 266. 266.
Yes.
This is a DFO to so and so 1. Is 9 BN ITB Lohitpur situated, lordship got it, in Udayamanjan Reserve Forest? If not situated in Udayamanjan Reserve Forest, then may kindly furnish me the details of efforts seeking information by written. Reply: the land occupied by 9th Battalion ITB at Lohitpur was diverted in favor of 2nd AR Bhait so and so for an area of 145.41 hectares as per below land breakup. Udayamanjan Reserve Forest 48.4.33 hectares.
Yes.
Lordship got it?
Yes.
Denim US 16.60 hectares. USF Lohitpur 80.377 hectares. So if you plus 145.41 hectares. Now, my lord will kindly see number 2. They made it clarify. Is 9 BN ITB Lohitpur situated in any notified reserve forest? Kindly see the reply. The 9 BN ITB is situated in RF for 48.433 hectares in Udayamanjan Reserve Forest and 96.97 hectares in USF area, that is outside RF area. Now, my lord will kindly see, is 9th Lohitpur diverted for any reserve forest? If it is diverted area, then may kindly furnish me the requisition letter. Yes, the 145.41 hectares are diverted in favor and was transferred in favor of so and so, so and so. So, my lord, now your lordship has got the details, which are the lands. Now, even again we made an RTI Your lordship has got the entire details of the land. See at page 269.
Go to
269.
yes.
See in A, D is important, my lord. C and D is important. Please furnish whether any USF land has been notified in Arunachal Pradesh. No, the USF is not notified. USF land is not been notified by the state government, any of the USF land. Now D, please furnish the notification of de-reservation of Uday Mazam RF and Denning RF was done for public purpose. It is nil. So it is still an USF unclassified state forest. Now, my lord will kindly see.
But what about the answer to C?
C.
C, serial number C.
Yes.
Please furnish whether any USF land has been notified in Arunachal Pradesh.
Yes.
No, USF
Has normally no USF land has been notified by the state government. It's a community land, they have not notified. Normally it should have been notified. All the lands. There is no notification of USF. We have done a lot of cases, there is no notification. Your lordship can, I think my learned friend also can give a reply to it. As far as my knowledge goes, my lord, there is no notification of USF land. Because these are all community land. Which are reserved for RF, it is reserve forest. Which are not a reserve forest, those are community land or individual land. So now, my lord, will kindly see one more RTI which is made is at page 275. Your lordship have got it. They already I have pointed, I think. It's again the yes, please furnish the notification. This is 20 Forest Department. Please furnish the notification copy of the above mentioned RF notification so as enclosed. Please furnish the map of the aforesaid. Please furnish whether any USF land has been notified. No USF area has been notified in this division. Please furnish notification of de-reservation of and denim reserve was done for public purpose. No de-reservation of so and so denim has been done. So there is no de-reservation has taken place because you have to. Because suppose you have a government also, the reserve forest, there is certain procedure which has to be done. They have not done it. Now this is what we made an RTI, and there is a circular issued by the state government at page 282. On the basis of this circular, at page 282, the rights, what are the rights being given to the landowners and in respect of community land, and what is the customary practice? All this is on 1st of July 2018 at page 282. The cabinet, lordship got it? The cabinet in his meeting dated so and so noted the observation made by so and so. Indigenous tribal of Arunachal Pradesh has inalienable land rights being the landowner and the right over the resources. The community and private land right has been recognized by ancestral through customary practice, has been passed over next generation to generation till today. Accepted a recombination of community land compensation is must for acquisition of land term as Jum land in local language, extinguishment of rights in USF area. As regards the rate of payment of acquisition of such kind of land, cabinet decided in views of different geographical region in the state and land having different economic potential in various areas, the respective DC land acquisition collector may fix the rate as per prescribed legal provision guideline issued by government from time to time. The cabinet also approved the proposal that in case villager agree, the land can be acquired at rates less than the published rates of respective district. And in case the villager or a particular area do not agree with the published rate of concerned district on the ground acquisition of a particular piece of land only.
So, Mr. Das, ultimately, your case, is it that out of the total area under occupation of the ITBP, 96.977 hectares is also occupied, which is unclassified state forest.
Yes, that's my, yes.
That is, and
That is our
since
case.
they are in illegal occupation, you want your compensation to be
I
either,
want the
you-
comp-
I-
either you acquire it,
the land.
acquire the land, and that is admitted by the state government also as a design. These are the land because they have given RTA reply. What was the last time your lordship just recollect? What my learned friend who is representing the ITB, what is saying that no, already we paid
No,
money.
that part yesterday, we were in the discussion, whether
Yes.
it is a compensation allowance, a compensatory allowance in the Kampa,
Yes.
under the scheme of Kampa, or whether it is compensation after an acquisition of land or
Yes.
requisition of land.
Yes. My lord will kindly see one, I will try to like to trouble your lordship with the land manual, what chapter 6. You can read this. There is a marking in it, my lord, but
You can give the concerned pages.
yeah, I'll give it, my lord, the concern page. My lord, same page, I think. Page in Annexer 20. This is,
Page.
I'll give a copy. That becomes more easier, isn't it? More details.
Pages
I think it will become more easy. Because reading,
Pages are at the bottom, you can say the page,
yes,
bottom, on the foot, right side.
no. I have, it is not with me, that's the whole problem.
No,
But your
on the
lord-
right bottom,
Yes, no, it
pages are
is,
there.
yes,
It's a different book or what?
yeah, yes, no, the same chapter, kindly see State Rehabilitation Resettlement Policy 2008.
No, if you,
My lord will kindly take
just
this.
have a look, on the right bottom, you have the,
Right, yes.
right bottom, you have the page numbers, you can flag it. Right bottom.
Yes, bottom there is, your lordship has got pagination. I don't have the pagination. I can give it to your lordship.
You can give the concerned pages.
Yes, yes.
Photocopy. It will be convenient.
17110. Chapter 9. Yes, I'll just give the 2 pages important. It was chapter 6. Yeah. 6. My lord will kindly chapter 6. Page 110. 110. Lordship got it? 110.
And resettlement. Policy of 2008.
Yes. R&R policy. See the 6, my lord. Present mode of compensation package at chapter 6, page 110.
Yes.
Present mode of compensation package 6.1. At present, the compensation provided to the affected people by any requiring body for acquisition of private land, immovable property, agricultural land is just a provision of Land Acquisition Act 1981 between the requiring body and the affected families, community in consultation with the state government. 6.2 is important. In case of diverted forest area, irrespective of its legal status, the present set of compensation provided by requiring body has 3 components, namely 1, cost of raising compensatory afforestation, 2, net present value, and 3, rights and privileges enjoyed by tribal people living in and around forests. The cost of raising compensatory afforestation net present value of diverted forest land are collected from the user agency and deposited in the fund of compensatory afforestation, fund management of and planning authority CAMPA, created for the purpose and constituted by the government of India in pursuance to Honorable Supreme Court. This is what, my lords, in their affidavit, they said 1 crore they have paid. This is what they have paid. That's the compensatory cost, which in paragraph 8, that at page 354, ITV affidavit, at page 354, which my learned friend day before yesterday has stated that we have already paid, amounting to 113.45. Your lordship, for a moment, see that affidavit. This is only a compensatory afforestation, my lord. That has to be mandatorily paid. Now, my lord, why this is being paid? Kindly see, for the purposes also given. After that, the tribal net present writer, the cost of raising compensatory afforestation and a net present value of the diverted forest and collected from the user agency and deposited in the fund of so and planning authority CAMPA created for the purpose and constituted by government of India in pursuance order. The cost of compensatory afforestation and NVB are charges mainly to redress the loss of forest and environmental services. This is the reason. This is not that he is saying that no, we have paid the compensation as if the payment has been done to the forest. This is the purpose, my lord. My lord, am I clear to your lordship, my lord? Now, my lord, will kindly see 6.3. 6.3. The rights and privileges over the tribal people which automatically get 6.3. The rights and privilege of tribal people which automatically get extinguished on diversion of forest land are compensated monetarily. However, the monetary compensation against diversion of USF area provided to affected tribal people does not consider an account for the right of USF land used by community, clan, individual. The state government levies royalty on removal of trees so and so from USF area for commercial use purpose. Therefore, present mode of compensation recognize only the non-commercial right of tribal people and not the purposeful loss USF land use cost to the community. Now, they have also quantified what is the amount that has to be paid. For USF and net present value, your lordship will find chapter 9. At this chapter 9. 119, my lord.
Yes.
My lord, kindly see chapter 9. Compensation, so and so. Deputy Commissioner being the forest, so and so. Next, my lord, 1. The payment may be termed as a compensation for loss of customary right and collection of forest produce and traditional land use of USF. Number 2, Deputy Commissioner in his capacity as Forest Settlement Officer, assisted by Land Revenue as Settlement Officer, shall work out compensation for the loss of rights and privilege of the tribal people to collect and use forest produce from US at the rate of 1,56,000 per hectare for USF area, rupees 78,000 per hectare for reserve forest land. If any, this is reserve forest, they have to pay. That's the difference. Constitute reserve for base year. Now kindly see number 3. In addition, case of diversion of unclassed state forest, the community shall also be paid compensation against extinction of their traditional right over USF land use at the rate 25% of net present value as determined by the government of India from time to time. This compensation to the committee is over and above the net present value paid to the CAMPA. This is what the provision, because last time, my lord, my learned friend was not having that book, but here it is laid down that number 1, land compensation has to be paid as per LARA, but so far as if it is USF land, then you have to pay this compensation cost to those unclassified stated forests which it belongs to them. And over and above net present value has to be paid. So my case before your lordship is very clear that till today, neither the government has acquired the land. They should acquire the land. If they acquire it because it is under their occupation, ITBB, or what they can do it, the period which they are occupying, they should pay our lease rental till the date, or they return back the land to us. Let them return the land back to us. This is the only alternative what they have. If they doesn't require the land, the purpose for which they have used, for that the whatever lease it comes, they have to pay to us. And thereafter they can vacate and return back the land to us. And it is the case where my lord, my learned friend read out at page 354 on the last occasion. Your lordship has already gone through it, of the affidavit filed by ITBB. And where my learned friend has said, and already we have compensate by paying this 1 crore to 13 lakhs. This is, I have said, this is not that. This is one has to pay it over and above. This is a campa. You have to pay it. So my prayer is very limited, my lord. And this particular, they have identified and they have stated in the RTI that reserve forest is 48 point some acres of land, and rest is the USF land, which belongs to us.
Yes. What do you say?
My lord, our stand is clear, my lord, in the affidavit, our affidavit, my lord, at page 346. What we have stated with regard to the USF. 346, para 7. This is by the secretary land, my lord.
346.
Yes, my lord. Paragraph 7. Merit, my lord.
That as regards.
Yes.
Paragraph 6 of the writ petition.
Yes, my lord. The humble deponent begs to state that the circular dated 1/6/2018 issued by the Secretary Land Management Department of Land Management Department, Government of Arunachal Pradesh, was in pursuant to the cabinet decision dated 10/5/2018 taken on community USF land, which when such lands are diverted and acquired for public purpose. As per the said circular and the cabinet decision, the indigenous tribe of Arunachal Pradesh has inalienable rights over the land and its resources. When such lands are diverted for public purpose, the indigenous tribe must be adequately compensated for the extinguishment of customary rights and privileges over such land. The deponent also states that unclassified state forest is not notified by the government, and hence the ownership belongs to local populace, and the indigenous tribes of Arunachal Pradesh has inalienable rights over it, and a person cannot be dispossessed of his land except by due process of law established by law. The deponent further states that Chapter 9 of the Rehabilitation and Resettlement Policy 2008 deals with the matter when a USF land is diverted for development and other projects and compensations thereof to be paid. As per Chapter 9, Paragraph 911, the payment is termed as compensation for loss of customary rights of collection of forest produce and traditional land use of USF. Under Paragraph 912, the Deputy Commissioner, being the Forest Settlement Officer, shall work out the compensation for the loss of rights and privilege of tribal people to collect and use forest produce from USF at the rate of 1,56,000 per hectare for USF area and ₹78,000 per hectare for reserve forest, if any rights and privileges are granted by notification constituting reserve forest. Further, under Paragraph 913, in case of diversion of USF, additionally the community shall also be paid compensation against the extinction of their traditional rights over USF land use at the rate 25% of NPB paid to Kempa as determined by the government of India from time to time. This makes it very clear. Even in the reserve forest, Malad, at the time of notification as reserve forest, if some rights are given to some individuals, then also they will have to be. In case of USF, it totally will, the ownership remains with the local population, community or individual. This was of a cabinet decision in 2018, but the RNR policy, what my lord has seen, it also speaks about the same rights over the of the individuals, indigenous people. The RNR policy, if my lord will see, the preamble itself at page 106, I'll not burden my lord. Preamble and all. Objectives, chapter 2. At 107, chapter 2, the basic objectives that should govern the state policy on rehabilitation of project affected families, acquisition of immovable property, private land, including agriculture and horticultural land, and compensation against diversion of forest area, especially USF area over which community enjoys right of land use and various privileges to meet their bona fide requirement of forest produce are as follows. All this.
So how do you wish to resolve this matter? Your stand is very.
Out of the total area, my lord, 145.45 hectares.
141.
Yes, my lord.
At least 96 appears to be
Yes, madam.
unclassified
Yes,
state forest.
Yes, madam. They will be entitled for that 96. The stand of the land department, the deputy commissioner and the forest department is the same. Madam.
Mr. Kato,
Ma'am.
you said that your compensation is paid. That what Mr. Das and Mr. Ratan also from his submission, it appears that this compensation do paid. It only amounts to the discharge of liability responsibility under the CAMPA, compensatory allowance.
Well,
This has nothing to do with their rights being affected. What do you give in lieu of the rights being affected?
well, from the affidavit filed by the other respondents, it is very much clear, that that stand has to be taken by the state respondent, who was the actual owner of the land, Now, the very fact of the case is, this has changed the circumstances, earlier it was occupied by the Assam Rifle, it has been given to the Assam Rifle, and when this piece of land has been initiated for the transfer in favor of the ITBP after taking over the land from the then Assam Rifle, the government of India approved for the diversion of this the 145.45.
When did you come into picture from Assam Rifle?
2000 2004 and 5, my lord. This piece of land has been taken over from the Assam Rifle, my lord, and in the year 2004 and 5, my lord, when the ITBP was inducted in the state of Arunachal Pradesh. my lord. Earlier, my lord, it was under the peaceful positions of the other than Assam Rifle, my lord. Of course, the ministry is different, my lord, but it is under the government of India, my lord. Now, my lord, when my lord, this piece of land is initiated for the transfer in favor of the ITBP, my lord, this land has to be first of all diverted from the the initial the forest land. It all comes under the forest land, my lord. Therefore, my lord, the diversion for objective of the diversion for this particular piece of land is giving the land to the ITBP and the user agency, my lord. When that was initiated, my lord, from entire 145.45 acres of land, my lord, hectares of land, my lord. The diversion is, my lord, the diversion has been granted, but classified has been given, my lord. If, my lord, the peruse, my lord, once again, the affidavit filed by the respondent number 8, out of 145.41 hectares of land, my lord, 48 has been, my lord, is considered as reserve forest, my lord, and 96.977 hectares is USF, my lord. My lord, because of that initiation, my lord, for transfer of this piece of land, my lord, this has come into picture, my lord. Earlier, it was not like that, my lord. So therefore, my lord, under these circumstances, my lord, what the contentions of the ITBP is, my lord, on the last occasion also, my lord, my submission was the payment to the tune of, my lord, as of now, my lord, we have already paid 2 crores 26 lakhs 90,000, my lord. Total payment, my lord. On 3 occasions, my lord, we have paid 2 crores 26 lakhs 90,000, my lord. And now, my lord, admittedly, my lord, in our affidavit also, my lord, categorically it has been mentioned that it is a compensatory afforestation, my lord, admittedly, my lord. Now, my lord, earlier, my lord, this land was falls as forest land under the custody of, my lord, the forest department, forest. Therefore, thereafter, my lord, the approval has been granted by the Union of India, the Ministry of the Environment and Forest. Now, the acquisition, the position, till from the initial to till this transfer of land in favor of the ITBP, in the year 2002 only, so therefore it is within the ownership was with the Forest Department.
No, you said that you had taken over from Assam Rifles.
My lord.
When was it allotted to Assam Rifles?
Assam Rifle, my lord, it was, as I have pointed out, my lord, in the year 2002, my lord, everything has been clear. It has to be diverted in favor of me, ITBP.
No, you came into the picture from Assam Rifles.
My lord.
Earlier, it was allotted to Assam Rifles.
Yes.
When was it done?
It was done in the 2002, my lord.
And when did you come into the picture?
2004, 2004 and 5 months. So therefore, my lord, it was very much within the position, my lord, the ownership at that relevant point of time.
Assam Rifles is also a party here.
No, my lord.
Suppose we intend to allow this petition.
My lord.
Not allow in the sense whatever is entitled to we recognize. Then what about the period of 2002 to 2004? Who will take responsibility of this period?
That is the, my lord, our contention.
From 2002 to 2004, he is representing, though he is the deputy SGI, he is representing the ITBP. Because Assam Rifles as such is not a party.
Yes.
For 2 years, Assam Rifles was there. And if you're asking for compensation.
No, I'm not asking from the Assam Rifles, the period which they have occupied. What we are asking compensation the period which they are occupied from 2005 onwards.
Okay. That means 2002 to 2005 you may forego.
Yes. From 2005 onwards, on the face of it, this is what.
He is more interested after you had come because things have crystallized. Now they can make a claim from you. Earlier it was.
Fair enough, my lord, to my understanding, my lord. It is fair enough, my lord. However, my lord, the contention of the my lord, the one ministry has already paid the compensation, my lord, in respect to my lord, as we have already, my lord, categorically stated in the my lord, it is in the affidavit, my lord.
Who? Who has said?
My lord, in our affidavit,
Oh,
it
you
is
have said,
clearly,
okay.
yes, my lord. It is clearly stated that, of course, the ministry is different, my lord, but Union of India has once paid. It is the alternative arrangement made between the, my lord, the, both the ministries, my lord.
But you have very fairly admitted that this 2 crore 26 lakh 90,000 amounts to compensatory allowance under the CANPA.
Correct.
Now, so far as unclassified forest is concerned, we are not on the reserve forest. Reserve forest, they may not have any rights because they cannot even utilize or be in position for reserve forest.
Madam.
But there are other forests which are not notified as reserve forest,
Correct, madam.
which is termed to be unclassified state forest, where the community still enjoys the ownership. The once their lands are taken over, their rights are affected. So you have to, whoever takes over has to pay the compensation in accordance with law. And either you have to acquire the land by involving the state district administration, or if you do not lend the, do not want the land for a permanent purpose, then the requisition amount you have to pay, the rental
Yes.
amount, the lease.
My lord, another aspect is, my lord, again, my lord, this is, my lord, my lord, this fact is, my lord, the another, my lord, aspect is, since they are already occupied the land, my lord. Now at this belated stage, my lord, now notification can be, my lord, the issued or not, that another aspects comes, my lord. Now, it is not the case of, my lord, the press acquisition, my lord. This is a case where, my lord, the already land has been taken over by the ITBP, my lord, from the Assam Rifle, even not from the, my lord, the individual owner, my lord. District administration, my lord.
You want to contend that 2004-5, whatever has happened has happened. Now in 2020, what what were you doing all this time?
Correct, madam.
The aspect of leches in coming to the court. But don't you think it's a continuing cause of action?
Now, my lord,
As on today
after,
also he is entitled.
my lord, after so, my lord, the attending, my lord, so many years, my lord, now it was the case of, my lord, 2000, my lord, 1962 to till, my lord, the handing and taking over by the ITBP in the year 2020, 2004 and 5. Now, my lord, after, my lord, this period, altogether, my lord, the 25 my lord, years or 30 years, my lord, now they are claiming back again. Where, my lord, the substantial development in the, my lord, the land has been already taken place by the, my lord, this force.
No, one thing is settled in land acquisition. It is the rate which was prevailing at that time. It's not a acquisition done today.
My lord.
It will be the rate prevailing at that time. These we need not point out. These are settled principles.
And my lord, another there in before this honorable court also, my lord, there are so many petitions are pending, claiming, my lord, the land has already been given to the, my lord, this organization by the petitioner claiming back.
Sir,
after
Ratan, as an AG, why don't you advise the state to identify all such lands? Because we don't want any windfall also to be come. They are also central government agencies doing a great job. Why should unnecessarily they be burdened with payment of huge amounts? But at the same time, the rights of the individual citizens cannot be denied. You can identify all those areas because so far as AP is concerned, vast areas are in the position of military forces, paramilitary forces, and all the areas may not belong to the community also. Now taking a cue from this, everyone may claim tomorrow, I am also a community, this land is mine.
Everybody comes in, my lord, started claiming back the
And if
land
the
which has already been transferred.
Officials, few of the officials are not scrupulous, then anything can happen.
Yes. But many litigations have crossed off.
You should do a due diligence exercise, find out. And there may be many who are not even able to approach the court, but their lands have been taken away.
Yes.
My lord, to sum up my submission, my lord, that is the contentions of the ITBP, my lord. Once the compensation amount has already been released, my lord, it is the understandings of the, my lord, Union of India that this, my lord, includes everything, my lord.
Yes, we had passed an order, I think today or day before yesterday. In a similar kind of a matter, where, who was appearing? Oh, Mr. Pada was appearing. yes.
I was also in that case,
Oh,
my lord.
okay.
In that case, my lord, direction has been given, my lord, but the requisition has to be.
Yes, yes, within, I think the ultimate direction would be a similar one.
My-
But we can earmark here that it can only be confined to 96.977 hectares,
my lord.
which is a part of USF.
Yes.
It cannot go to the other areas, total 145. Out of 145, only 96 is
96.977.
977.
Yeah. Well, what my prayer before your lordship is that why the government takes the initiative for acquiring the land. That will be, and again, these are the clans, villages, which again, they have to run every year for collecting. Once it is, they take over, ultimately they require ITV.
Mr. Das, we cannot force somebody to
No, no,
acquire.
I'm just
But
requesting.
in the other order, we have said that if the nature of occupation is permanent,
Yes,
then you have to acquire.
yes.
But if you think that nature is not permanent, there is likelihood of us vacating the land, then at least the requisition amount, the rental amount,
Yes,
lease amount.
definitely. That's why I'm saying.
My lord, that
But
decision
I
has
have been-
appropriate authority
I
to
have
form
been-
that decision.
my lord,
my lord,
what
I-
I have been told that it is a permanent.
No,
Full-fledged.
it appears to be permanent for the
Yes.
last 25 years.
25 years. That's why it appears to be permanent.
And so for a strategically located state,
Yes,
it cannot be temporary.
yes.
There is requirement.
And what
very
my
much requirement.
what my learned friend said
Key pocket,
about
my
the,
lord.
we paid the compensation irrespective. It is a forest and maybe a reserve forest or not a reserve forest. A compensation cost has to be paid.
Yes.
That has to be paid. That is not they cannot absolve it saying, no, we paid the amount. As if they have paid the compensation.
Okay, we will consider, okay? Heard. Read us. The Senate Council for the petitioner assisted by Sri S.R. Rava. Also heard Sri N. Ratan, learned AG for the state, as well as Sri M. Kato, learned deputy SGI, representing the ITBP. Respondent number?
124, my lord.
Respondent number 124. The hearing is concluded. The judgment is reserved.
Madam.
Kindly make, we do not need the entire book. Kindly make the photocopy of the relevant
Photocopy,
pages,
Yes,
Mr. Khan, and give it to our court master.
my lord. My lord,
Deep
sorry,
level.
one indulgence I am taking your lordship. Item number 46 with your lordship consent of my learned friend is today not possible.
Why it's not possible? We are having,
No, hearing matter 46.
we are having, we are not rising. Who said we are rising?
No, no, I know, my lord.
We have come here to finish off matters.
No, because I
No
think,
rest.
my lord.
Rest till we up to 4:45. Yes,
If
next
it is-
matter.
If it is possible, and if it can be taken on.
We saw Mr. Fukan sitting for a long time.
No,
We thought we'd
Fukan
take
is
up his
okay.
matter.
My lord, we have to, the
We
problem.
don't want to send him just like that.
My lord, because this is a matter.
Unless he wants to go back.
My lord, this matter, I think the army is also the representative. Army is your power.
40?
Yes. 46, my lord. 46.
What is the
My
matter
lord,
about?
this matter, this is a land acquisition matter. Once the learned single judge has decided the issue.
18 matter.
Yes, yes,
Mr.
that's
Kato,
why.
you are there.
My lord, in fact, this matter has been taken up by, my lord, the Vaidoloi, my lord.
Why don't?
I'm also there, my lord, for Union of
Why,
India.
what
my
the request has been made?
Basically, my lord, the Vaidoloi is for, my lord, the other respondents, army, my lord.
Army.
Defense
But I think it not look good in the last decision we have quoted Vadilal. Here, there should not be any disparity between what is coming from you, what is coming from.
Correct,
Both
my
are CGC, both are representing
Ah,
the
right,
Union of
right.
India.
One,
Two wings speaking in two different voices. That is deprecated by the Honorable Supreme Court in Vadilal case. We have quoted that case.
My lord, I'm sorry to say, my lord,
You have to
basically,
speak in one
Vaidoloi
voice.
is for
Correct, correct.
Two
principal
wings of
seat,
the
my lord.
department will not mean that you are two individuals. You're part of the department. And that too Union of India.
My lord, I'm sorry to say, my lord, he is from the, my lord, basically for Guwahati, my lord, I think, my lord, the defense state officer, my lord,
How
taking
does
the
it make
service.
a difference?
Yes,
He's
ma'am.
from Guwahati, you are from AP. All you are from the CGC, Deputy SGI.
My lord, department head, my lord, they taken the services of, my lord,
No, we are not against the services, but there's cannot be two different opinions, one coming from you,
Correct.
one coming from him.
My lord, one
So you tell us, we'll give
one
a,
humble request, my lord, if it is possible. Mr. I have asked the other side, or if it's possible, take on 28, 20. To Tuesday. 20 and 21 continuous for 2 days, then we'll try to finish, my lord. Subject to your lordship, if accepted. 20, just a making
what
a
about
request.
Mr. Doloi?
Dolo, yes, he's a consent is at 20. 20.
We cannot say, we can fix it.
Yes. Yes.
We can fix it, but we cannot assure anything.
But only one request, if your lordship permits, on that day 28, can I just mention it, my lord, on that day, if this matter will be on list? Because
If there are no other matters, we can definitely take
Yes,
it,
my
but it
lord,
depends on.
if this matter, if it not inconvenient, can be kept for 2 days, 20 and
2 days, we
21.
cannot say.
No,
We'll,
if it is possible, suppose it.
no, if it spills over, we can
Spills
have it.
over,
If it
spills
spills over,
over.
we can.
No, I am just telling was spilling, if it spills
If
over.
it spills over, we can accommodate, that's not a
Yes,
problem.
that's
But
why.
whether it reaches on 20th, that's one
Yes.
issue. Because motion matters, we suddenly found
It is on.
number of motions coming up.
It is on Tuesday, my lord, at night.
Here, Tuesday, Thursday, there is no difference. See the number of motions today.
I have seen that, my lord. Only a request, my lord.
Okay, or 28th, huh?
28.
Item number
46, my lord.
on a request made by the learned counsel for the parties. Matter is adjourned to be listed on 20th,
20.
25, 2020.
Item number 21 and 22.
That please. My lord, this
Madam, I'm-
matter pertains to tender.
But
The
I'm
lordship will-
appearing in 22
Yes.
For the,
for the
Private
private
respondent.
respondent number 5, man.
May lordship, the.
which department? PWD,
RWD.
RWD.
Yes. My lord, this tender pertains to construction and maintenance of the vibrant village. My lord. 21.
21. We can take up for disposal.
Yes, my lord.
How much time will you take?
My lord,
It takes some time.
it'll take some time.
What is the issue?
My lord,
Allotment of work
yes.
in a tender process.
Yeah, but my bid has been rejected, my lord.
Rejected.
Yes.
On what is the stage of your rejection? Technical stage.
Technical stage.
Now, what is the status of the work? 90%.
No.
Earlier, that was after some time it was withdrawn. It was refiled again. In that,
There is no stay order.
No, it's the-
So far as we are concerned, madam, we have also completed part of the work. Art cutting is over,
Your work is a different work,
Yes, my lord.
different work, man.
where Mr. Tafu is also participating in the
Yes,
tender
ma'am.
process.
Yes.
Yes, man.
These are two different works.
Different.
In both the works, you have been
Say-
rejected on the technical ground.
Yes. ma'am.
Okay. And so for Mr. Panging, your 90% you have done. What is the work?
Construction of road. ma'am.
Roads. And Mr. Mazumdar? your-
Same, my lord.
No, no,
Madam.
how much work have you done?
Madam, so far as we are concerned, art cutting is completed and the next stage of work we have already started. Madam, in
Madam,
this
this-
case,
What are your grounds?
My lord, what we are saying in this repetition is, my lord. First of all, the manner in which this tender was rejected, my lord, is bad, my lord, that we are saying. And secondly, my lord, lordship will see same tender documents because different places, different tenders were, my lord, in vibrant village programs by the same, issued by the same authority, my lord. What happened, I participated in many tenders, my lord. That same advertisement. In what we have categorically stated in the petition, same documents, everything was same. I was placed before the same authority. They have accepted one of the bids.
It was accepted
And qualified and
for a different contract.
same project.
No, for a different contract.
Different, of course, different project.
Now, those documents have been rejected so far as this work is concerned.
This, regarding this, they have rejected, but that other work they have considered and accepted our bid, and we were allotted.
Yes, Mr. Tarak. How can it be inconsistent if you have?
That where he have qualified is after 2 months. This was before.
Well, the pitch was placed on the same time.
I did not get you. What?
No. In one, here they have participated in 3 packages. Out of 3, these 2 packages was evaluated before 2 months. So they bought a package, his technical bid was rejected. Then after gap of 2 months, another set of bid document was evaluated. So in that package, he was
Or different set of documents.
and the same, maybe they are claiming same set of documents.
No, but you have to say, you are the authority.
But that part, that where you have qualified, only date of bids, they have, date of evaluation they have given me. Whether that was same set of
No, but
documents.
if it is the same set of documents, if you have found them to be eligible and qualified, you cannot reject them.
Now, this rejection was made earlier.
And by the same department.
Yes.
Same department.
Same authority.
This rejection was earlier.
Earlier, yes.
Well, the opening was done after 2 months. That's different. But the tender, I uploaded was same time, same documents, in all the
But
tenders.
if you have the same department, how can you have 2 stands? If you have in one work, you have considered one of the document to be eligible, qualified. In the other works, by the same department, how do you disqualify him? And it is for you to say that the documents are not the same. If you say so, then matter will be different. That you are not saying.
That part I have no instruction.
No,
No, why you are saying you're not saying? Because Mr. Tafu has based his case only on that, only on that foundation.
Yes.
And that if you have to address that foundation, you have to say that no, documents are different.
This Honorable Court already directed the.
And why do you oust persons at the technical stage? Why didn't you have a competition at the financial stage? He may not still get the work in the financial bid system.
They have not denied in the affidavit, madam. They have not denied the fact.
Mr. Mazumdar?
My lord, so far as I'm concerned, I can have.
No, so far as the allotment of the work to you or Mr. Pangi is concerned,
My
we
lord.
may not find too much of fault. We may not even require to go into
My lord.
how it has been given to you.
My
You
lord.
are mainly examining the
Whether-
rejection of Mr. Tafu's bid, and in that process, you are the beneficiary. So therefore,
My,
you have been heard, and you can argue upon your eligibility, your qualification, but
my lord, my lord.
his rejection has to be defended by Mr. Tarak.
Yes, my lord.
And he doesn't have the instructions today, and things are not very clear. Signs are not signs, just like luminous.
If I may just point out, that is not the main ground in the repetition. That is in the paragraphs it is there, but no documents were annexed. That is the difficult.
No.
My
We have
lord,
any
my lord,
Documents have been annexed by the repetition.
my lord,
we are
one
not
submission,
comparing these
my lord,
three
one
things.
submission I would like to make.
Yes.
In the writ petition, my lord, there are 3 grounds on which the petitioner's bid was rejected at the technical bid stage. Now, in the writ petition, I find only one word that he says that I have submitted. He could have produced his bid document to say that, see, you say I have not complied with these terms of the tender notice, but I have complied. That he has not done. He is only saying one word that I have submitted. Apart from this, there is no other statement in the entire writ petition. I have
No,
checked the writ
Mr.
petition.
Mazumdar, Mr.
My lord.
Mazudo, pleadings are very important in our writ proceedings.
My lord, my lord.
We don't have the expertise to have evidence.
My lord,
Only the pleadings supported by the affidavit.
my lord,
But here, if he is making out a case
my lord.
that the same documents have been held to be okay for another work by the same department, we have to see why this has been not
My lord, one
taken
submission.
into consideration
My
so
lord,
far
your
as the
lordship is
present
correct.
work is
My lord,
concerned.
one submission I'll make. Had it been a case where one particular certificate has been issued and this has been accepted in respect of one tender, and not accepted in another tender, matter would have been different. Here is a case, my lord. One of the grounds on which his tender was rejected is that at the construction site, certain materials are to should be present, and he could not show that these materials are present there. So there is no question of rejecting the same document in respect of other. It is a question of having your materials, having your technical
But
person
that,
present.
Mr. Tarak is not pleading this to be a ground, that this is the ground, that he did not have the materials.
No,
No,
Madam,
that
that
we
is
have
the
my
Madam, that is
affidavit.
the ground on which it was
Yes,
rejected. Madam, that
Malad,
is the
may kindly
ground.
see 9/4/2004 order, Malad. This honorable court has already directed the Senate Council to produce the document, Malad. 9/4/2025.
We have the documents, or we have the evaluation records.
Evaluation record, we have filed affidavit. of-
No, where is the evaluation record
My
by
lord,
which you have rejected his plea?
Madam, page
Yes.
121 in the petition is there.
Ground of rejection is in the writ petition itself.
Writ petition itself is there.
Kindly see
Madam,
9/4 order, Malad. 9/4.
petitioner has produced.
Order.
9/4 order?
Yes.
9/4.
Yes, 2025.
There is no 9/4, there is 3/4.
9/4.
9/4, 24 or 25?
25. 25.
There is no 9/4, there is 3/4 and
Malad, I think in the second 22, Malad. Yes, I think on 22.
9/4.
Yes, Malad.
Madam, at page 121 is the impugned beat evaluation report at page 121.
Just a minute, he wants to show 9/4.
Yes,
Let us
Malad.
see what is 9/4. Nine-four, yes.
Yes.
What is 9/4?
Well,
Repeat of
Professor-
learner so-and-so submitted in connection with so-and-so. Petitioner submitted his bid, but on the basis of his tender document, the respondent will, however, on the same set of documents submitted in so-and-so, the petitioner was adjudged to be a technically qualified and awarded with the award. Accordingly, he submitted on this document, therefore, the court is inclined to direct RDG to produce the scanned copy of
Yes.
the document to upload it.
Yes.
Have you done so?
Document last occasion I brought, but.
Bring the documents.
Yes.
If it's gone as an order of the court, we like to have the documents.
Yes, we'll.
Okay,
I'll-
yes,
When?
yes.
Tomorrow?
Tomorrow.
Tomorrow, Mr. Mazumdar, or
All right,
Monday?
Madam. Madam, page 121, just for a moment,
No,
Madam.
you
Lord.
should- Mr. Tarak, you should be in a position to bring the documents. Just do not say yes. 4:30, 4:15. Will you be able to get the documents today?
Monday.
Monday. Okay.
Monday.
My lord, just for a moment, page 121, Lordship will have a look. Page 121, just for a moment, of the writ petition, my lord.
Which one? Which one?
Which second,
That will
item
be-
20,
which one you want?
22, my lord.
WPC 619.
My lord, my lord,
619.
my lord.
120.
1.
Yes.
My lord, this is the order, bid evaluation report under challenge. Now, page 122, the authority has given the reasons for finding him his bid non-responsive. My lord, the second table at the
120?
bottom, 122,
One?
next page. 122,
Okay.
next page.
Yes.
My
Yes.
lord, there are two
The
tables.
original-
The table at the bottom, serial number 4 is the writ petitioner. Lordship has seen he was found
NT.
non-responsive. My lord, NT, yes. Now it says
4.4. B.
4.4B, B1, then 4.4B, B2, then 4.71. Now, first one, your lordship will find at page 43. Just for a moment, my lord. Page 43. I'm sorry, page 42, my lord. 42. 42. 4 point, lordship has got, my lord. 42, my lord.
Yes.
Look, at the
Yes.
bottom, 4.4BA, then small b says each bidder must demonstrate. Now, 1. Availability for construction work either owned or on lease or on hire.
Yes, we've got
of
each
the
bidder
key
must
equipment.
demonstrate.
Yes. Now, this ITB, as per appendix to ITB, which is available at page 56. Lordship may kindly see 56 now. 56.
Yes.
Page 56, madam.
Yes.
Now, page 56 is the appendix to ITB. The table below shows name of equipment machinery. Now, the requirement is these machineries you must be having there on the site, or you must be having these documents. It's not a question of submission of some same document for two tenders. It is a document where you have to show that these documents are available. So unless you satisfy the authority that these materials are available with you, there is no question of accepting of one document for one side package, one not accepting the document for another package. It's a question of
It is not a kind of
availability.
it is not a kind of a certificate by the bank. or
Absolutely, my
financial
lord. Absolutely, my lord.
institution
I'm obliged, my lord.
Or
Or any other document
these
accepting
will
the,
depend on the ground reality.
my lord, my lord, my lord. That's
Did,
what I'm
did,
saying.
did you physically verify the documents so far as having the equipments at site?
No,
Was
no,
it done?
this was not required to be put at the site. It was documents had to be uploaded in the website. That's all.
My lord, one of the ground is also he have participated in, as he admitted.
No, Mr. Tafu, there is
Yes.
one, what Mr. Mazumdar has pointed out, perhaps rightly, the clause
Yes.
on which your technical bid has been rejected has
Yes.
been specified.
Yes.
We have gone to the clause. One of the clause also talks about the name of equipment and machinery
Yes.
which were required to have at site.
No, no, not at site.
Same set of document he have annexed in all the tender where he have participated. Same set
Documents
of
we have to upload.
machinery, same set of technical personnel. So suppose if he is
No,
awarded,
what Mr. Mazumdar is trying to say and what we have understood
Yeah.
is not verification of the document. It is the
Exactly,
verification of the site condition. Did you verify the site condition?
He must
Site-
have,
Regarding documents of having this technical machineries, that has to be
Yes,
uploaded in
yes.
the tender. That's
Okay, we'll have it on Monday then. But bring this, comply with the order, okay? Heard, repeat Afu, learned counsel for the petitioners in these two cases. Also heard Sri G. Tarak, learned standing counsel, full stop, Sri Mazumdar, learned senior counsel, who has appeared online, assisted by Sri P. Bora. Okay. Who is assisted by Sri B. Kaushik and Sri D. Pangi, learned counsel appearing for the private respondent are also present. Full stop. Sri Tafu has drawn the attention of this court to the order dated 9/4/2025. Yes. Passed in WPC 619 AP 2024, as per which the learned standing counsel was directed to produce scanned copies of certain documents. Full stop. Sri Tarak, the learned standing counsel, has submitted that though on the previous occasion the said documents were with him, today it is not readily available. Full stop. In view of the above, the consideration of these matters are deferred and the repetitions be listed on Monday. Would like that.
my lord. Deeply applied.
The transfer and
Mr. Sharma, where, which matter? 23.
23 laws. And then there are some other matters also. Series matters also.
Yes, what is it? What are these matters?
Well, this impugned transfer posting order was put into challenge on the ratio laid down by this honorable court in Hibutama case, wherein there cannot be interstate transfer between a similar, non-similarly situated officers. Now, here pursuant to the absorption of all the employees of the DRD to the RD department, then this private respondent who was sought to replace me was a technical assistant. So I am a urban project officer, which is in the rank of AE. Now, therefore, by order dated, by this order, second last order,
I would be seeking some time. So what has happened herein is
You have filed affidavit.
I filed my affidavit. On the last occasion, a clarification was sought as to whether my position, as it's been shown as an APO, is still an APO or not, pursuant to the absorption of the DRDO into RD department. Now, an affidavit has come. In fact, I was given a
They are DA,
Yes, Lord.
not O.
DRDO.
DRDO.
From
No,
DRDA. DRDA. Sorry,
Don't
Lord.
say DRDO.
DRDA. Agency.
In today's context, DRDO is different.
No, DRDO. Defense issue is going on more, so DRDO.
Maybe the last moment of the court hours, my.
Okay, you want some time.
Yes.
They have filed an affidavit seeking clarification, which is
Who has
against.
filed?
No, sir.
Petitioner has filed.
No, the respondent department has filed.
Okay, you want to seek instructions?
Yes, I'm saying it's from my client.
Okay, when, tell us,
At his convenient, my lord. Maybe
tell us.
Monday, Tuesday, my lord, I will be in Delhi.
Tuesday, Wednesday,
Next week.
After the
19th.
19th, fine, my lord.
19th.
19th, I have another matter. So
19th Monday.
yes, 19th will be. Yes, your lordship, Monday.
Monday is okay for you.
Fine,
Monday,
fine,
this matter is also there.
19, no, I will not be there.
Not the-
19, I will not. Be
Then we have it on 26th.
Fine, my lord.
Yes, lordship,
Fine.
26th.
Heard Sri T.T. Tara, learned counsel for the petitioner. Also heard Picha for department.
I'm for 3 lords.
Respondent for the state, for the department, whereas Sri A. Sharma, learned counsel is present for the respondent number 3. Full stop. On the prayer of Sri Sharma, the learned counsel, the matter is adjourned and is directed to be listed for admission on 26/5.
Interim order to continue.
Para, interim order passed early to continue till the next date of listing.
Oblige, your lordship.
Okay, rest will give dates. Any urgent
Item
matters?
number 25 to 36 and 48. They're all similar matters.
What
I've
is the
already-
subject matter?
This is basically, lordship, we are from All India Limited as a respondent. Now, what had happened, All India was given an area within that particular area in that Doyung Reserve Forest for exploration. Now, these petitioners have come challenging the eviction notice issued by the Forest Department against them, saying that they are staying in a revenue village and therefore they cannot be evicted. So because of that issue, there is a stay order. So therefore, as respondents now, we have not been able to explore. So that is our urgency in these matters. The issue can be otherwise very solved in a very easy manner.
What do you say? What is your right? You say it's a,
It was my village was there before it was declared as a Anchal Reserve Forest. So
The forest has filed an affidavit clarifying that this
it's
is.
a
Doyung
reserve forest,
It's a reserve
it's
forest.
a Anchal Reserve Forest. That
unclassified, state forest.
yes,
Is
Anchal
it-
Reserve Forest.
Huh?
Anchal Reserve.
Anchal Reserve.
Anchal,
It
what
is
is
a-
Anchal Reserve?
Anchal Reserve.
What
So-
is Anchal, what is the difference between reserve and Anchal
Because
Reserve?
Anchal, there is a.
There are categories of reserve forest, my lord.
But it comes under reserve forest.
No, that's the villagers have the right over the Anchal Reserve Forest to share the revenues and everything.
Okay, we'll have this. You may have something to address very, yes, Mr. Mo?
48 item may be taken together with this.
Similar matter also.
Tell us the date of your convenience of the
Can it
council,
be on 18th of June?
18th of June,
There is a stay order operating. So
18th of June. 18th of June is, I think, too long if they stay order operating.
because now we cannot explore this because of the stay order. They are still there.
We'll have it on 9th of June, is it okay?
Thank you.
9th of June, 9th of June,
Okay,
okay.
I will try.
Please give the case numbers in a list. Please get the case, which were, what are the numbers?
From item number 25 to 36,
Duty are appearing in all the cases?
all the cases.
And 48.
48 ESMA, huh? Right, and A. Sharma for IOC,
Oil India.
All India. And Ratan appearing,
Yes, ma'am.
and Parme, you are also there. Anyone is appearing? Okay. Paucity of time will not permit the matters. It's for orders otherwise.
It was for orders because they were
Item
supposed to
number
file
48
reply.
is for hearing because the pleadings are complete hearing. It's the same issue. They're all from the
Now,
same.
can we
same
take it, can we make a mention that it will be taken up for disposal?
Yes, your lordship, because the affidavit they have filed, the forest has filed item number 48, we cover their case. from the same area. They say we are from that revenue village.
Okay, the paucity of time did not permit the matters to be taken up today. As agreed to by the parties. Learned Council as agreed to by the Learned Council for the parties. List these PHS, these matters on
9th of June.
9th of June. Okay.
For admission hearings also.
Then interim may be continued.
Oh,
Or hearings.
maybe rules not issued.
Not issued.
Okay, for admission.
My lord,
Till that time, your honor, interim may be continued.
Some unlisted motion is there. What is the unlisted motion?
Interim.
Arbitration petition, why? 11 petitions.
Also, that matter may be taken up if possible on Wednesday.
Wednesday. If you want a notice, we can issue notice.
Yes.
Where is your,
Lordship, my
where is your?
my notice to them. My notice to them is on page 26.
26.
Yes, your lordship. It was sent through email. 25 is the email. 26 is my notice,
26.
which it was sent to the respondent, sole respondent. On the top of it, Mr. So and so. He is the authorized representative of PRL Gapong Joint Venture. And subsequent.
Please write. Hard Sri K. M. Mahanta, Learned Council, for the petitioner who has filed this application under section 11 of the Arbitration and Conciliation Act 1996.
Yes, sir.
As amended.
Yes.
For appointment of an arbitrator.
Yes.
He has drawn the attention of this court to the notice issued on 7/4/2025 demanding such appointment which has not been responded to.
Yes.
Sir, let notice be issued, returnable on. Respondent is from
Yes.
the state?
Yes, from the state.
Returnable
So-
on 9th of June.
Please, your honor.
Let steps be taken for service of notice upon the sole respondent by registered post PTD. Steps within 2 working days.
Deeply obliged.
And the other one? What is this? Unlisted CRP?
Also, the date, on the item, the 9, maybe some other date, not 9 June.
Tell us when, 10th, 11th?
Yeah.
11th?
Yeah,
11th, huh? Hey, what is the CRP?
Unlisted item number 50.
Yes, that is, what is it?
Your lordship, this civil revision petition, this is against the order of, against the execution and enforcement order issued by the circle officer PG Riang Pakikesa. So your lordship, the fact of the case is, during the year 2021, the petitioner and the respondent, despite they had the option of being land settlement land disputes got settled in the village authority, they resorted to
You had a
one.
dispute.
Yeah,
Petitioner and respondent had some dispute
Yes.
over a plot of land.
lordship. They resorted to, instead of going to a village authority, they resorted to get it settled through a deeds of agreement.
There was a deed of agreement.
Deed of agreement,
You amicably settled the matter.
lordship. And in that, and interestingly, your lordship, in that agreement, the signatory was the circle officer, and subsequently deputy commissioner also countersigned it. And after that, what happened? After they coexisted happily for 2 years, and after 2 years, all of a sudden, the respondent, they just submitted a complaint before the circle officer PG Riang. And this circle officer, assuming, presuming, and considering these deeds of agreement as the decree or judgment passed by the village authority, he has issued an this one execution order. So subsequently, based on that execution order, deputy commissioner in 2 occasions had served summon to the petitioners. So your lordship,
where is the summon?
Summons page number 44.
What is section 4.2 of the Arunachal Pradesh Civil Codes Amendment Act?
Section 4.
4.2.
Yeah. Your Lordship may come to page number 61.
What is your name?
Your Lordship.
What your name?
Rima Taipodia.
Oh, Arnaba. Or
Rima Taipodia.
Rima Taipodia. Okay. Yes, what do you say?
Yeah.
Your Lordship, this order is execution order, Your Lordship. In consequence to the order passed order passed by the village authority decision, Your Lordship.
Where is the village authority decision?
This is a deeded, this is written as a deed of agreement. Otherwise, Your Lordship, all the criteria, all the requirements has been fulfilled of hearing of an dispute.
Okay.
Open the
Heard 3 R Taipodia learned counsel for the petitioners who has moved this petition under Article 227 of the Constitution of India, challenging, inter alia. The action of the Deputy Commissioner to issue summons to the petitioners on 2 occasions for in connection with an agreement. Full stop. The petitioners have contended that a land dispute between them and the private respondents were settled amicably via a deed of agreement, which was also countersigned by the circle officer and the deputy commissioner of the concerned district. Full stop. It is also contended that for 2 years the agreement was acted upon, and suddenly the respondent number 3.
3, 4, and
And suddenly the private respondents have instituted a complaint to the circle officer. Full stop. It is the specific contention of the learned counsel that construing the agreement to be a decree of a court, summons has been issued and an execution proceeding has been initiated. Para? Let notice be issued, returnable on 2nd of June 2025. Ms. Sangeeta, the learned State Council accepts notice on behalf of respondent numbers 1 and 2 that extra copies of this petition, don't say read petition, petition, be served upon her by tomorrow. Let steps be taken for service of notice upon the respondents 3, 4, and 5 by registered postpaid AD. Steps by tomorrow. Para, the learned counsel for the petitioner prays for an interim order. Full stop. He has drawn the attention of this court to the deed of agreement dated 22/1/2024, upon which the execution case has been purported to be drawn up. Upon consideration of the same, it is directed that till the returnable date, further proceedings in what is the proceeding? Is there any proceeding number? Further proceedings which has been initiated upon the complaint dated
16/3/2025.
16/3/2025, submitted by the private respondents. All the 3.
Yes.
Shall remain suspended. Para? Since this order has been passed ex parte qua the private respondents, make it italics, huh? The said respondents may come up for modification, alteration, / cancellation, if so advised.
Much obliged.
Right.
Okay, rest
Madam-
dates will be given. Yes.
May I have the permission, Lord? Item 41 and 42, my lord. This is basically according to me, my lord. I am appearing for the respondent number 7, private respondent. I have moved an IA for vacating the status quo order, my lord.
41 and 42.
42, my lord, because this has become infractious because the order says there is a division bench order, my lord. This is basically land acquisition. The LA appeal has been confirmed, final, repeated
You
repetitions.
can have it whenever tomorrow, if you want, we can have it tomorrow.
I have no difficulty, my lord. My lord.
22nd.
Yes, 22nd.
In that case, I'll come back, my learned friend, I will.
22nd is a Thursday.
Can it be on 21st also? my lord?
Yesterday only the respondent authorities has filed their affidavit in opposition.
My lord, what has happened here, my lord? The award has been upheld in the LA also. This is repeated
Okay,
repetition.
we will have it whenever you say.
22, 22nd.
22nd, okay. 41, 42, huh? The paucity of time will not permit the matter to be taken up today. Full stop. As the applicant, as the learned counsel for the applicant has expressed urgency and as agreed to by the, and as agreed to by the learned counsel for the opposite parties,
Yes.
let this matter be listed on 22nd.
Yes.
22/5.
Very
Okay,
good.
rest dates will be given.
Grateful, my lord. My lord, item number 43, order item number, my lord.
40?
43, my lord.
Yes.
This is an IA, my lord.
IA.
Subject to lordship convenience, my lord. Can it be taken up on
IA for?
20, my lord?
IA for?
Condonation of delay, my lord.
Condemnation of delay. Notice issued.
Notice, my lord.
Okay, we'll have it on Monday,
Monday,
20.
20, my lord.
20.
Tuesday.
Give 20. Okay.
My lord, item number 24. Maybe fix tomorrow.
Tomorrow, not tomorrow. Tomorrow we've got many matters. Have it on next week. Any day.
Your Lordship,
Interim order plus earlier may be continued.
I will give the
Your Lordship, item number 46 may be fixed on 20th this month.
20.
40 item number
He'll
46.
give that. Make a request to the court master. Court urgency na thakle potok kane diba.
Obliged.